ಬರ್ತಾ ಇಲ್ಲ.
Listed yesterday at serial number 52, my lords. It was called in the lunch as my lord. I was not present and it has been directed to be listed after 2 weeks. So may I request any date? There is an interim order. I'm seeking vacation of. It was called during the lunch hour and I was not present. I was under the impression that it was called during the lunch hour. I was not present.
In all that interim orders are extended.
No, I'm for the respondent. I'm seeking vacation of that interim order.
No, I'll not give.
My any date.
But with kind liver, date given matter not listed, I mentioned the urgency. Please.
With my lord's kind leave, my lord, if I may be permitted to make a mention.
ಹೇಳಿ ಸರ್, submission ಮಾಡಿ.
My lords, serial number 33, my lord, in list number 1, my lord. Please.
Number 1, page number 2, serial number 5 to 8.
My lords, serial number 6, my lords. I am for the petitioner. Some settlement talks are going. Kindly have it after week after next, my lords.
This is matter for 4 weeks.
Yes.
Page 3, serial number 9 to 16. Page 4, 17. From admission, page was adjournment. Page 9, 40 and 41.
Serial number 18, my lord.
Page 10, 42 to 46. Page 11, 47 to 51.
Serial number 47, my lord. Serial number 47, my lord.
I appear in
Petition.
I appear
the petition number 2 weeks time to imply the office objection.
Your Honor, we object to this adjournment. I appear in item number 47 for the petitioners in the matter. On the last date, they had sought an adjournment that 47.1.
47.1.
Why you want time?
Office objections complied 2 weeks. Office objections.
We will see. Before office objections, we'll see what about the petition. Yes, next.
Page 12, 52.
Your Honor, just to clarify, the matter will be heard in the course of the day.
Page 14, 55 to 58. page 15, 59. List number 1.
My lord, serial number 33, my lords. My lord, serial number 33, please, my lord.
Written objection not called. For orders it is.
Please, my lord.
Being spoken, serial number 1. Chandrasekhar Nagshetty.
ಇದರೊಳಗೆ in this matter, my lord, company appeal by insurance company appeal was allowed. In the order portion, there is a typographical mistake. Instead of MFA, it is written as writ petition.
In order position.
That's only the typographical mistake. Only in the order portion.
For any repetition.
Yes. That's a, please.
Repetition kinds of insurance.
Tomorrow, trial court may object it. That's why I moved the memo.
Very much here.
Yeah. Please.
Serial number 2. What not matter?
This is the matter where my friend has submitted my notes. The matter is compromised before in a EP. But my notes, I could not, I tried to contact my trial court advocate as well as party. I could not get, but I verified my notes in the e-courts. It is sold, it is mentioned in the operative portion. Only award amount is satisfied. That is what it has coming. After disposal of MEC, we filed a execution proceedings. It has been closed as satisfied. Notes, my submission for my lords, whether that I could get the entire documents. One submission I want to make before my lords is, even if the EP is satisfied, only the award, please. Please, ma'am. Please. Please.
Serial number 3. Sunil S. Desai.
Petitioner, my lord. I seek a short accommodation, my lord. Since my lord, the council on record is not keeping well, my lordship. Council on record is not well, my lordship. He is not present today. He instructed me to take a short accommodation, my lord. Please. Please.
What happened to the council?
He is not keeping well, my lordship. Even I don't know, my lord. He just called me and said,
Under the same on
Please.
Wednesday, on the day, if the time will not be happening, and if any time is not, there is on the ground.
please.
18. Serial number 4. BV Somapur.
This is a plaintiff's petition. The defendant number 1.
I think it's short time on the last case.
Please, ma'am, I have verified the case. It is posted for evidence of the plaintiffs. It is still for evidence of the plaintiffs.
Then why did you not even press for an repetition of 2024? And now we have to put the clock back.
That is the.
By allowing, if all the court has to allow this repetition. Before we have to put the clock back for 2 years.
It is a file on in the 29/8/2024. 2024. Yes.
What is this petition about?
Application for that is recall of the order, placing him ex parte, and allow him to contest the matter. He is the father of the plaintiffs. Between the family, suit for partition and separate position. Partition suit.
So that the dispute between the parties will be able to a logical.
Yes.
Where do you get the order?
That it is a 1/3/2021, he is placed ex parte, and the order is passed on 21/7/2024, my lord. At page 44. Order, impugned order is at page 44.
Have you find a copy of it? Type copy, what is this order?
It is defendant number 1 has shown sufficient reasons to allow the I number 8 on cost of rupees 2000 it is allowed. Even allow antanu andilla hanga pare cost of rupees 2000 ಅಂತ. Rupees 2000. The defendant number D1 has shown a sufficient. Typed copy is at page 46, my lord. Typed copy is 46 page.
The plaintiff is before this court. The plaintiff had filed suit seeking partition.
Partition is separate position.
Partition and separate position. In that, who was the ex parte? Who is the defendant number?
Defendant number 1 is the father of the plaintiffs. He placed ex parte.
On
1/3/2021.
On 1/3/2021.
And he filed application on that 8/11/2023. And in that application, he stated, shown the reason that he has shown that he placed ex parte on 28/6/21, but it is wrongly mentioned.
Now, by order imputed 1/7/2024, the court has passed on case called off, transfer the plaintiff as an objection, heard both sides. Even has shown sufficient reasons to allow I-1 and allowed it on cost of rupees 2,000. When counsel appearing for the petition of plaintiff submits the court has not passed a detailed order. No reasons are stated in the petition. We submitted that when an IA is filed, it has not been delayed. The court often has given the reasons for the accused is on that count alone. The order include needs to be set aside. It's on a query from the court. We submitted that the matter is at the stage of evidence.
Even if it is IA is allowed, in the IA, he has sought for a recall of the order date 28/6/2021, and it is on 28/6/2021, different order is there. It is not for on 28/6/2000, it at page 18, my lord. Page 18, 1/8. Case called out, no representation is made for the plaintiff. Call on for hearing on IA and tasta iti. There is no order as such for recall of the order of the ex parte.
The order is shown as dated 1/7/2024. There is no stay for this court. Now the matter has come up for this court. For hearing. The petitioner, it's a question for partition. The defendant number 1 is none other than the father of the petitioner. In a suit for partition, the rights of all the parties shall be crystallized. And in that manner, it can be taken to a logical end. And basing on the evidence that is within the parties, the court should give an authoritative pronouncement which will put an end to the litigation. As rightly argued and enhanced for the petition, the order dated 1/7/2024, no reasons are given by the court. Right from 1/7/2024 till the suit was proceeding and evidence of the parties considering the peculiar facts and circumstances of the case, where the facilitation of partition, and as now and it is only an ex parte order that is necessary. And no review would be passed to this, the said order is set aside. And this court is not inclined to go to the
Preliminary hearing matter, seal number 5. Girish Sharma.
Yesterday's matter, my lord, wherein
the appellate authority has already granted interim order status quo.
yes, ma'am.
State.
That was my instruction, my lord. Subsequently, I got instruction that, my lord, that appeal was disposed of because the original appellant, my lord, had died when the matter was pending before the DDLR. In fact, my lord, before his death, the DDLR had ordered for fresh survey. Noting that, my lord, the order. The ADLR. In the suit, original defendant.
And your dependency of the same. The version is consent and the reason before the authorities, right, as the same is supposed. Take out answer number stay.
Please, grateful.
Stay. Seal number 6, urgent. Seal number 7. Sharon Basavaraj C.
For petitioner. Annexure A is under challenge. The endorsement issued by the first respondent. Please. Please. He is the commissioner. It is the endorsement, my lordship, wherein, my lordship, the application of the petitioner for renewal of the gun license has been rejected on the ground that, my lordship, the petitioner has attained the age of 60. As such, there is no lack of life threat, my lordship. Lack of life threat.
Yes. Yesterday,
Yes.
similar matter, my lordship, please. Yes. My lordship will pass reasoned orders.
And my lordship,
Yes, yes.
that is, and even he is renewing only for 2 years, my lordship. He is renewing only for 2 years in other cases, my lord. As per the provisions of the Arms Act, my lordship, it is mentioned as 5 years.
Petition is filed seeking the following prayer. Arms Act, give the act, yesterday you have taken Arms Act, same that provision you extract. Not necessary. The present petition is filed seeking the following prayer. It is a case of the petition that the petition is a resident of Dharwad district and is residing in the place, not at Dharwad district. Is residing in the same address from last more than 20 years. Is an agriculturist and was an ex-corporator at Hubli Dharwad Municipal Corporation. Considering the threat the petitioner is having, he has applied for the arms license and the license was granted on 11/3/2018. And from time to time, the said license is renewed. And the license was still 31/8/2025. Then for renewal of the license, after following the procedure, he has sought for the renewal before the second respondent. Pursuant thereto, the police authorities have conducted the inquiry and the antecedents verification. And respondent number 2 submitted a proposal to respond. Who is the authority? Respondent number 1 is?
Respondent number 1.
R1, my lord.
Or 2, respondent number 2 has submitted a proposal to respondent number 1. That is this renewal application to first respondent. Second respondent has submitted a proposal to the respondent number 1 for renewal of the arm license of the petitioner. There is the respondent number 1 by the endorsement impugned has rejected the case of the petitioner for renewal on the ground that he has attained the age of 60 years and as such he has no threat. When counsel submits that the said finding given by the second respondent, the observation of the second
First
respondent is without any material and without any basis. When a thorough inquiry is conducted by the second respondent and when a report is placed before the first respondent ought to have considered the same and ought to have given a reason for not renewing the license of the petitioner. It is contrary to section 14 of the Arms Act. It is admitted that the endorsement impugned needs to be set aside and expelled. Learned HEA appearing on behalf of respondent number 1 and 2 submits that as there is no life threat to the petitioner, the first respondent has rejected the renewal of arm license and it is a well considered order. Having heard so and so. The renewal of the grant and renewal of the license is as per section 14 of the Arms Act. Section 14 of the Arms Act reads thus, extract. Whenever an authority, as per the powers vested under the Act, is passing an order or considering the request, he has to give the reasons. And without any reason, just like that, the second respondent, the first respondent, ought not to have stated that there is no threat, basing on which material he has come to the conclusion that there is no threat to the petitioner is not forthcoming. Whenever an order is passed by the competent authority under the Arms Act, rejecting the renewal of license, the same should contain the reasons. This court, in several cases, is coming across the orders passed by the commissioner, competent authority, in renewal of the licenses, gun licenses, where in one line, the finding is given and it is not, there is no mention about how the authority has come to such satisfaction. Hereafter, whenever an order is passed, whenever an order is passed, rejecting renewal, that should contain specific reasons. Coming to the facts of this case, the endorsement impugned is bereft of reasons and the same needs to be set aside. Accordingly, this court is passing the following order. The endorsement dated so and so is set aside. The first respondent shall pass a reasoned order while considering the application of the petitioner for renewal. Number 3, the principal secretary, Home. The order of the copy shall be circulated to the principal secretary, Home. In turn, he shall instruct all the concerned to pass a reasoned order whenever an application is filed seeking renewal of the passport. Registrar Judicial is
renewal of the gun license.
Registrar Judicial is directed to communicate this order.
Right.
Yes, next.
Seal number 8.
Yes.
Prashant S. Kadadeva.
Petitioner, my lords. Petitioner is the registered club, my lords. Petitioner is the registered club, my lords.
Recreation club.
Recreation club, my lords.
No interference by the
covered-
state.
Hmm?
No interference by the policeman. No interference by the police.
Then why are they coming to the court
My lords, even though
for a
it's,
similar order?
registered recently,
Huh?
even though it's registered recently, my lords, they are insisting for license.
As for the covered cases.
Yes, my lords.
The writ petition is filed seeking the following relief. It's a case of the petition that the petition is a registered club having its registered club conducting the activities and which is formed for the purpose of providing entertainment to its members, including the equipment and guidance for sports and playing games like caroms, chess, rummy, snooker. The games which the petitions club is conducting are games of skill and do not endanger human life, and they are not games of chance. It is the case of the petitioner that the respondents 3 to 4 are insisting that the petition secure a license from the authorities for playing games on the ground that the skill games are games of chance. It is submitted, it is a case of the petition that the police have no authority to interfere with the activities of the club. Next, for Leonard AGA, appearing on behalf of 1 to 4, submits that the respondent police are not interfering with the activities of the club. However, it does not dispute the fact that in a similar petitions, this court and the coordinate benches have passed several orders. Next, para. Considering the submission of the Leonard petition, having heard counsel for petition as well as Leonard AGA, this court is passing the following order. That operative portion is there, 7 number. Yes. Disposed of.
Disposed. Cell number 9.
My lords, there is other matter to be connected with along this. There is another matter to be challenging the same order taken along with similar order, my lords, between the same parties.
What is this writ petition about?
My lords, challenging the entire proceedings before the fourth respondent, my lords.
Call for the relevant records on the file of the fourth respondent. Who is the fourth respondent?
Deputy Registrar
of
Cooperative Society, my lords.
Entire proceedings, fourth is so and so. What are the proceedings?
Recovery proceedings, my lords.
Why it should be cash?
As my lords, as per the Cooperative Societies Act, my lords, within 3 years of loan amount, my lords, he has to issue a notice. In this, my lords, after 16 years, my lords, the proceeding has been initiated against me, my lords. Hence, the proceedings are.
Section 105, my lords, appeal remedy is there.
That's what, everything High Court only. But that apart, having an appeal remedy, 16 years. How can there be, when it is on the face of it contrary to law, contrary to the provisions of the Act?
Yes.
Please get instructions.
Please.
This is matter on Tuesday.
Could it be taken up on Monday, my lord? Monday.
Monday not possible. I'm not sitting on Monday.
Now there is little urgency. Now what they are doing is, they have filed an application seeking attachment of my agricultural property.
When is that?
It is posted on 17th, my lord. In the meantime, some protection be granted.
List this matter on Tuesday. It is submitted that the recovery proceedings are initiated after 16 years, which is not permissible under the Act as well as under the law of limitation, the recovery of the money. Considering the submission due to paucity of time, list this matter on Tuesday till such time not to take any questions.
Grateful.
Then
The number, my lord, other, my lord.
list
Other
of
number,
so and
yes.
so. Learned AGA takes notice for all the
R-
respondents.
R1, my lords, R1 only.
R1.
Others
Who appears
notice,
for the other respondents?
other
My
notice has
lord,
to.
they are the, my lord, sureties, they are shown. I'll file application, my lord, seeking dispensation of notice to respond number 2 and 3.
2 and 3 memo is filed. Give the memo.
I shall.
Dispensation of notice. Yes.
Great.
Next.
And respond number 1, my lord, notice has to be ordered.
He appears for respondent number 4.
He is, my lord, for respond number 4.
Respondent number 4, 1 hand summons.
1, my lord, notice will have to go.
Hand summons.
Great.
Respondent number 1, he is permitted to take hand summons and file a memo to the effect. Yes.
Great.
Yes, next. Yes.
For the petitioner, my lords. So this petition is filed, my lords, invoking my lords supervisory jurisdiction because, lords, the petitioner is Uttaradi Mutt, and my lords, the dispute is with respect to respondent
Take
number.
the prayer.
Please, my lords.
Issue a writ or direction.
Directing the trial court, my lords, not to precipitate.
Proceedings on the file of the disposal of civil.
Yes, my lords. I'll brief the facts, my lords. May I, my lords?
You will come for that to this court.
My lords, what has happened is, my lords, the plaintiff, the petitioner Mutt and respondent 11 Mutt, lords, are disputing the Moola Brindavana.
Will you ask the court or you don't ask?
Lords, we, my lords, made a submission before court stating that, my lords, there is settlement agreement in place. The same has to be reported before the Honorable Supreme Court, wherein, my lords, retired Justice, my lords, has been appointed as a mediator. Pursuant to it, my lords, the settlement agreement is, my lords, executed. But, my lords,
It's not going to all that. I'm asking you one simple question.
please.
Has this request been made by way of, it should be by way of an IA
Yes, my lords, we have made,
order?
my lords, we submitted settlement agreement before the,
You want the proceedings to be stayed
yes, my lords.
till the SLP, whatever is pending before the court. What you are supposed to do? You are supposed to file an IA before the court seeking stay of the proceedings in the light of so and so. If they don't, if the court doesn't pass any order, passes an adverse order, then you will come to the court.
Yes.
Straight away, will you file a writ petition?
My lords, can you take notes order sheet, my lords? Can you take order sheet at my lords?
To 227, we will not exercise in this manner. You have to go before the court, seek an order from the court. If it is not, either it is not disposed or it is another order is passed, come here. Why will the High Court be exercising and 227 will say stay the proceedings without any order impugned before the court?
That's only not to precipitate, my lords, until, my lords, the same.
Bravo, that is not permissible under law. Please come. The present writ petition is
My
filed
lords,
seeking the following prayer.
for once, my lords, can you take my lords to the order sheet, my lords, at page number 329, 330, my lords.
You have to understand what I'm saying.
Yes, my lords, I
Whatever
understand.
it is,
But we are not
seek and invite an order from the court. File an application. If the court is not hearing your application, then come to the court. Court will say dispose of that. But we will not just because court is not doing something, we will not pass an order saying the suit till SLP is pending.
Lords, the same, my lords, is observed in the order sheet itself, my lords.
What is that observed?
Lords, may I read, my lords, page number 330.
That is not an order. You file an IA.
Lords, based on the IA, my lords, the order has been passed at page number 330, my lords.
Where is that?
Lords, can you take page number 330, my lords?
Then what is this prayer? What is this prayer?
Not to precipitate the matter itself, my lords. Yes, my lords, I understand, my lords, the order, my lords, passed on the IA has not been, my lords, produced before this honorable court. But, my lords, the order sheet, my lords, reflects, my lords, the observation made by the trial court, my lords, with respect to IA filed by us, my lords.
Then what you should say? So and so docket order dated so and so has to be set aside or something you should ask. How can you say that let the court issue a direction to the trial court to stay, not to proceed with the matter till SLP is filed?
Yes, my lords.
This is not a writ of mandamus you are seeking.
Yes, my lords. On, my lords, 23rd of January 2026, my lord, we filed a memo seeking deferment of all interim applications.
Please show which para, which page.
It's page number 330, my lords.
330, yes, read it.
Learned Counsel for Defendant number 1 filed memo to defer the hearing of all interim applications on the ground that the matter is pending before the Honorable Supreme Court of India for mediation in respect of suit property and other properties, hence prays to defer the hearing of all interim applications till settlement before the Honorable Supreme Court.
For objections on your memo, it is posted.
Lords, on 7/2, my lords, settlement agreement was also reported before the trial court, my lords. But, my lords, The same was not taken on record and
Whatever you say, the court can't do. You file an IA. The respondents want to file their objections. Settlement is between both the parties, not alone you will file the settlement. When they are filed, that is what the court said, for objections by 7/2/2026. And in the meantime, you have come here.
they have not filed objections, my lords, but my lords, the suit is filed by representatives of the both the mutts, my lords, petitioner mutt and respondent number 11 mutt. my lords.
Present petition is filed, sing the following prayer. It is a case of the petitioner that they filed an IA.
But liberty may kindly be granted.
Where is that IA? Where is the IA? Copy of the IA?
IA may not produce.
Huh?
Order sheet as we have filed.
IA sheet is even what you have filed before the court also, not before the court. File an IA. Not to proceed with the proceedings in OS number 35 of 2024 on the file of the Principal Civil Judge JMSC Gangavati till the disposal of civil appeal number 1376706 of 2024. It is a case of the petitioner that the court is proceeding with the matter without this deciding the IA. As such, they have come before this court. Next paragraph. Having heard the counsel for the petitioner, per the material on record. The petitioner wants the stay of the proceedings till the SLP is decided. In that case, he has filed the IA number 2 or 8.
This
is IA number
8.
IA number 8. The plaintiff prayed time for objection to the said memo. And D2 submitted that there is no settlement in respect of the suit property before the Supreme Court of India and prays to file objections. Hence, the court has adjourned the matter to 7/2/2026 for filing the objections. In the meantime, the present writ petition is filed.
Lords, may I pass on this order sheet, my lords. Both my lords, the defendant number 1 and
Whatever it is, that is not the jurisdiction of this court. That you have to understand. Let it be anything. You may have 100% a case on the merits of the matter. Whoever, now you file this petition here, I don't pass any order. On that, will you go to Supreme Court? You cannot. What did you do? In the meantime, the present writ petition is filed. The petitioner cannot come before this court seeking such a relief. If the court, any application is not heard by the court, he can seek a direction from this court to expedite the hearing. And just because the court has given time to file the objection, that is also on till 7/2/2026. Now it is already, we are on 12th of February, and the petitioner cannot seek a direction from this court on whatsoever reason to stay the proceedings of the court. That is impermissible. The petitioner has to invite an order from the court, but not from this court. Accordingly, the writ petition, the petitioner cannot maintain this writ petition with the relief as sought for. However, considering the facts and circumstances, this court is passing the following order. The court shall consider the IA number 8 filed by the petitioner as expeditiously as possible. Number 2, this court is not proposing to issue notice to the respondent, as this court is not passing any order on the adverse to the interest of the respondent. Yes. And after hearing the parties, the same shall be disposed of.
grateful minutes.
Yes.
So number 11. Girish.
This is concerning, my lord, the KSBC election day before yesterday's matter, my lord, request for change of place of voting. The COP states that, my lord, she is practicing at Jamkhandi, which is already on record with the KSBC. However, at the time of preparation of voters list, my lord, the
What do you
place.
see? What are your instructions?
I got the instruction that as per the Honorable Supreme Court order, my lord, any grievance with regard to the election, it is to be placed before the high-powered election committee, my lord. Hence, this writ petition is not maintainable, my lord.
Yet to
And for that
secure that
judgment, I'll
order.
produce it later, my lord. At another half an hour, my lord, I'll get the judgment order. Because
1
I
o'clock.
received it now.
1
my lord.
o'clock.
1 o'clock.
Please.
Please, my lord. Grateful.
Pass. Seal number 12. Top
My lord,
SS.
for the petitioner, my lord. This writ petition is filed by the life convict, my lord, seeking direction to the Union of India to take a decision on the recommendation made by the central government for premature release. My
It
lord,
is
page
taken by
number
the state
19 is the
government.
state government. Sorry, my lord. So recommendation made by the state government to central government for concurrence because the petitioner
Why
is
every day
convicted.
we are getting these kind of restrictions?
Minutes, Annexure D. My lords, now the prayer is against the Minutes Union of India.
Huh? Why?
Prayer is against the Union of India, my lords. State has recommended as per Annexure E to release the, my lords, the petitioner as
Why?
premature.
What is the offense that is convicted?
My lord,
Convicted.
302 and 325 of SC/ST Act, my lord.
Then why the Union of India? Huh?
As per Annexure E, now the matter placed before the, my lords, Union of India, my lords. Annexure E in page number 44.
Oh, the other day when one matter has come up.
Yes.
In that matter, as per the proceeding, the government order, it will be considered
By the, my lords, that
wherever
committee.
for the remission.
Yes.
What is this case?
This case, my lords, the according to him, my lords, his case has been, my lords, placed before the Union of India.
Why? You please get specific
Yes, I'll get
instructions.
details.
Number one,
I take number one, my lords, Venkatesh Karve.
not the respondent I'm referring to.
Sorry,
The instructions you have to get, I'm saying.
please.
Number one,
Yes.
you have to get specific instruction.
Yes.
In all these remission matters, why everybody is rushing to the court, as per your own government order, why you are not following. Let your concern instruct you and place those instructions before this court.
Yes.
And what is what about this case? Why the Union of India have to take a decision in this?
Yes.
What is the nature of the case and under which provision that has to be done by the Union of India?
I'll take it.
So and so. Union of India, who represents
Ms. Venkatesh Karve.
so and so is directed to take notice on behalf of respondent number one. The AGA takes notice on behalf of
2 to 4 minutes.
2 to 4.
Yes.
This court every day at least one writ petition is filed seeking the relief as per the proceedings of the government of Karnataka. This is dated
1423, my lord.
1/4/2023. Why the respondents are not considering the case of the prisoners as per their own proceedings is not known. As such, the second respondent shall give specific, the AGA shall get specific instructions
Yes.
from the second respondent. What is the mechanism in place with regard to these cases of remission? Secondly, what are the instructions in respect of this particular case?
Yes.
This is matter on Wednesday. By the time the instructions shall be placed before the court. Next.
Bill number 13. Kiran Kumar.
For petitioner, my lords. Annexure F is, my lords, compromise decree, my lords. Compromise decree entered between respond number 1 to 6 has been challenged by the daughters of the propositors, my lords, by name Muttappa, my lords.
What is the suit for in which the compromise has taken place?
Suit filed by, my lords, respond number 1 and 2, my lords. Respond number 1 is the brother of the petitioners, my lords. Respond number 4 is the, my lord, he is also brother of the petitioners, my lords. Without
We're not a party.
not a party, my lords.
You are one of the brother.
I am appearing for I am sisters of the respond number 1 and 4, my lords.
You are the plaintiff sister.
Please, my lord. Without making me as a party to the suit, my lords, suit filed by the my brother and my brother.
Suit is when?
Suit is filed by my brother, my lords, and my brother's son, my lords. OS number 786 of 2024, my lords. Filed before
Compromise decree.
Page number 27, my lords.
Page number
27, my lords.
How old are you?
There are 4 petitioners, my lords.
Who are all of
Sisters,
them?
47, 3, sorry, my lords, 3. 47, 45 and 37, my lords.
These are all the daughters.
We are the daughters, my lords.
The land counsel appearing for the petition submits that the brothers, that is the respondents herein, has filed a suit for partition and have entered into a compromise. The petitioners, who are the daughters, are not made parties to the suit, and they have obtained a collusive fraudulent decree considering before the Lok Adalat on 2/7/2024. Considering the submission of the land counsel for the petitioner, there shall be stay of all further proceedings pursuant to the compromise decree dated 2/7/2024. Petitioner shall take out hand summons on the council.
Please.
Nothing is pending, so they'll issue emergent notice.
Seal number 14.
Please.
Malika.
This case, petitioner, my lord. In this case, petitioner is challenging the seizure of his car, my lord.
Seizure of?
His car, my lord. Car, motor vehicle.
Car seizure is also to the High Court.
Yes, because it is a taxation matter, my lord. Because, my lord, the charge is that, my lord, he is using the car registered in some other state, my lord. So, as per annexure, my lord, may I take your lord?
The car.
Because, my lord, page number 32 is the order, my lord, wherein my car was seized, my lord, on the ground that, my lord, I am using the car which is registered outside the Karnataka. So, without paying the motor vehicle tax, my car was seized, my lord. Again, immediately I have submitted my representation, my lord, stating that, my lord, as per section 3(1) of the Motor Vehicle Taxation Act, my lord, it is only if I used the vehicle beyond 12 months, my lord. Since I am a bank employee of Bank of Baroda, my lord, I have purchased when I was working in the Pondicherry, my lord. Now, as per annexure, my lord,
Under which provision of the act the vehicle is seized?
it is not mentioned in the seizure order, my lord. Your lordship may kindly see page number.
What is the procedure to be followed, Mr. AGA?
My lords, as per annexure K, my lords, in page number 36. This is the, my lords, he filed an application before the, my lords, the learned magistrate.
It is there before the magistrate?
Yes.
No, that
It
was
is there
rejected
before.
on the ground
And,
that, my lord,
the
it
learned
was
magistrate.
rejected on the ground that, my lord, the court has no jurisdiction to try the Motor Vehicle Taxation Act, my lord. I have produced the judgment also, my lord. May I take your lordship to the page number?
No, not about that. In this case, what has happened?
My car was seized, my lord.
Your car was seized.
And now they have issued a notice stating that, my lord, if I have not paid the penalty as well as tax, my lord, my car will be auctioned and the amount received in the auction will be deposited to the treasury of the state government, my lord. May I take
Kindly
one
see,
judgment
may I
of
take
this?
to, my lords, annexure K, my lords, this is order passed by the, my lords, third additional civil judge and JMFC Ballari. In
What
page
is the
number
order?
36, my lords, he filed application under section 457 of CRPC and under section 201 of the, my lords, the BNS Act. And the very specifically, my lords, para 3. May I take, my lords, para 3, in page number 38.
Registration certificate of the applicant, he appears to be a registered owner of the vehicle.
Please.
However, in view of section 15 of the Karnataka Arts Act, this court is not empowered to
Yes.
release
Yes.
the vehicle to
Yes.
the interim
That is-
custody of the applicant.
My lords, kindly see para 3, relevant portion is para 3 of that.
Para?
Para 3 of the, in page number 38 of the, my lords, the JMFC court order.
Yes.
The learned regional transport officer has filed objections on the ground that the application is not legally maintainable. Further contended that as per the averments made in the petition, this court has no jurisdiction to release the vehicle. Further contended that as per section 50.
What I'm asking, I'm really surprised.
Further, my lords.
The Motor Vehicles Act, if a vehicle is
Yes.
seized,
In similar matter, my lord, this honorable court has passed the order, my lord.
I have to see the provision.
May I
Yes.
take,
Similar
may I
act.
take further, my lords? May I take further?
Same issue was involved in the.
Maybe, but under what is, why should you come before the High Court? That you please show.
Please, my lord.
There is no mechanism under the act.
May I take further?
Act.
Section 15, my lords. Section 15 of the act.
Every writ petition just like that can't be entertained by the High Court. When there is a mechanism provided under the act.
My lords,
Section-
three lines I will read and stop, my lords.
Section?
Section 15 of the act, my lords. My lords, 3 lines in the observation I will read, my lords.
No, before that come to the
Please,
act.
please.
Levy of tax, section 3, my lord, 1957. Karnataka Motor Vehicle Taxation Act 1957,
Yes.
Section 3.
Mm.
In this case, my lord, it is provided how the tax has to be levied on the vehicles, my lord. My case is that, my lord, I have purchased my vehicle in the Pondicherry.
You have to tell whom, no, in a primary authority.
Yes, I have submitted representation also, my lord. May I take your?
Appellate authority, who is the appellate authority?
I have submitted representation also, my lord, immediately.
Who is the appellate authority, Regional Transport Commissioner or who? Who is the appellate authority under the act?
My lord, there is no appellate authority.
There is there, appeals are
It is
there.
there,
No. Yes, sir.
Section 15.
Please.
3.2, may I take your lordship, notwithstanding anything contained in subsection 1 or section 4, taxes
What
at,
this 15 deals with? Section 15
please, ma'am.
of the same act.
Any person who is aggrieved by an order of taxation authority made under this act may within a prescribed time and in the prescribed manner appeal to the prescribed authority. Taxation authority, my lord. It is not the case that, my lord, I have avoided the tax, my lord. The regional transport officer has seized my vehicle only on the ground that, my lord, I have used
Provision it is seized. There must be provision for anything.
only under section 3 only, my lord. They have to I have to pay the tax, my lord. If I use the vehicle beyond 12 months, my lord. May I take your lordship to 3.2 of the act, my lord.
No, you have to pay the tax.
I have paid in the Pondicherry, my lord.
No, the issue is with regard to the taxation, isn't it?
Yes, my lord.
That's how the vehicle is seized.
Yes, my lord.
So, no questioning that, why can't you go before the authority
No,
in
you are,
appeal?
that's why, my lord, this honorable court as well as the division bench also held that, my lord, as per section 3.1 of the act, it came to existence only if I used it beyond 12 months, my lord.
That why should we decide? That is what I am asking.
Because, my lord, section 3.1 is contrary to section 47 of the
They are
motor vehicle.
disputed
That has
facts.
been considered by this honorable court, my lord. Even it is taken into the division bench. Also.
Now, first of all, I want you to satisfy the court on the provisions.
Yes.
Where is the order?
3.2,
passed
3.2.
And what is the remedy available? Then we will look at the law.
Your lordship,
Yes.
may I take your lordship to annexure, my lord, impugned order, page number 32.
Yes.
This is a seizure order.
What did they say?
My lord, when stopped and checked the motor vehicle found playing on a plastic road, one motor vehicle found playing in Karnataka state without payment of Karnataka motor vehicle tax.
Where do you get the 30?
Page number 32, annexure H, my lord. Last.
So, if they have passed this order,
Yes.
there is a source of power under the act.
They have not mentioned any provision, my lord. That's why, my lord, I am before this court. Your lordship may kindly see, they can impose only under section 3.2 if I use the vehicle beyond 12 months, my lord.
That is also that what I'm saying is let us understand what they did. The remedy is not passing orders. Remedy is not each person comes to the court giving one order to everybody. That's not the what we have to do is we have to go to the root of the matter. What they are doing,
Yes, may I
what
take
power
lordship
they have,
3.2
and
of
if
the
they don't have the power, why are they doing? And we will tell them not to do.
3.2 may I take your lordship 3.2. Notwithstanding anything contained in subsection 1 or subsection 4, taxes at the rate specified in part B of the schedule shall be levied on a motor vehicle suitable for use on roads which are in state for a period shorter than a quarter, but not exceeding 30 days. This is the provision, my lord, wherein I have to pay the tax if I use the vehicle beyond as per this, my lord. But it has been.
Now this is what it says. Now, if you have not paid the tax,
Yes, my lord.
what is the procedure to be followed? It must be there in the act.
Yes, my lord. I have to.
Where is it? Show it from the act. Yes, list the matter on readiness. Please go through the provisions and then convince the court. Yes. You also please get instructions.
Yes.
Learned AGA shall get instructions.
Please.
Under what is the source of authority and power to the respondent to seize the vehicle?
Yes.
If the vehicle is so seized, whether any notice is required to be given or not, and once the vehicle is seized, what is the remedy to the affected party? Yes.
Seal number 15.
Here for the petitioner, my lord. I'm impugning the order passed by the trial court on IA number 3, my lord, directing the petitioners to deposit the entire compensation amount.
Entire compensation amount.
Please, my lord.
Where is that order?
Please, my lord. Page number 19, my lord, the reasoning. May I read, my lord?
Yes. Now the suit for partition, property is a joint family property.
Please, my lord.
You take the compensation from the authorities.
Please, my lord.
And what will happen if you spend the amount?
No, my lord. In the year 2002, the property, with the consent of the other,
When you have received the compensation?
during the, before the filing of the suit, my lord.
Date?
Date is not mentioned, my lord, but before filing of the suit only, my lord. What has happened is, my lord?
According to you, he has, plaintiff has relinquished the suit, his right, no document to that. And if you're permitted to spend that amount of compensation you have received from the 10th defendant, what will happen? How is it, it's difficult to.
No, my lord.
those
If I may
amounts.
invite your lordship attention to page number 27, my lords, the prayer sought by the plaintiff before the trial court, they sought only 1/9 share in the suit properties, my lords. Even
They sought?
1/9 share, my lords.
How much it comes?
It comes around 10 lakh and odd, my lords.
How much?
10 lakh and odd.
Let's see the plaint.
Please, my lord. Page number 27.
20?
7, my lords. The translated copies and product. Translated copy I'm producing, my lords. Page number 5.
Get the prayer.
Page number 5, my lords.
Page number 5.
Please. Can I read, my lord?
Respect to 1/9 share in the suit scheduled by affecting partition from disturbing each plaintiff with their one. How many plaintiffs are there?
2 plaintiffs, my lord.
So how much it comes? How many are the defendants?
Defendants, 9 members are the 9 defendants, my lord.
So they want 2 shares.
Please.
Now the amount is 1 crore.
Please.
And deposit 20 lakhs.
No, my lord. That has to be adjudicated only after the full-fledged trial, my lord.
Just now you said that it shouldn't be 1 crore. He is seeking only 2/9 share.
No, my lords. Without admitting, my lords, the plaintiffs are entitled to any share.
Instead of depositing 1 crore, the deposit to 20 lakhs.
I'll secure instruction, kindly. I'll secure instruction, kindly pass over.
This is matter on Thursday.
No, my lords. My pass over, my lords. I'll seek instruction.
Pass over.
Please.
Passover is before 1:30.
Please.
Seal number 16. Shivashuru.
Annexure D and F are under the challenge, my lord.
Annexure
D.
Come to the prayer.
Please, my lord.
Passing the impugned order passed by respondent number 2. Who is respondent number 2?
Assistant Registrar of
Order
Sour.
passed.
My lord, this is, I'll just brief the facts, my lord. In the year 2016, my lord, I have obtained a loan from the respondent number 1 corporation. In the year 2018, my lord, I was due of about 1,68,000 rupees. To that effect, my lord, I have issued a check, and that check got bounced. To that effect, they have initiated a enact proceedings, my lord. During the pendency of that proceedings, by suppressing enact proceedings, they have launched parallel proceedings before the respondent number 2. Here, my lord, in the enact proceedings, I got acquitted on the ground that, my lord, I have paid entire amount. By suppressing this, my lord, he has again obtained a award by the respondent number 2. Now, on that award, my lord, he has filed execution petition. For a moment, if your lordship take.
Award.
Sorry.
Have you questioned the award?
No, my lord. Since for a moment, my lord, may I take your lordship page 19?
Not question the award.
No, my lord, no.
No, without questioning the award,
Please.
how will you get the consequential execution proceeding state on whatsoever reason?
Please, my lord. Since I have already paid the entire amount.
It's true. You have to question
Rightly, my
that
lord.
award. And in that award, because you have paid the amount, you will get the stay of it when you question that award before the appropriate authority.
I understand, my lord, but since there is a limitation is prescribed under the Act, my lord,
When
I was
the
not
award
made
passed?
aware of this.
When was the award passed?
That is under 2022. And
What can't be done directly also cannot be done indirectly.
the execution is filed in 2025 November after lapse of 3 years, my lord. In the year
What
2.
expect the court to do? No, even if an interim order is granted,
Yes.
ultimately we have to give a reason for giving an interim order or entertaining the writ petition. When you have not questioned the award itself.
In this petition, I have challenged that award itself, my lord. Ultimately, my lord, I have to approach under section 34 before session court.
What is the limitation for that?
The 120 days.
Which can't be controlled.
And now, McCollum, since there is a fraud on the, because my lord, in the award, he has nowhere stated that he has launched parallel proceedings.
Bypassing the remedy available to you. No, a party who is not vigilant, who doesn't, take recourse to the remedies available to them, cannot come before the
But since I have satisfied the decree.
The AGA. You appear for the Assistant Registrar of Cooperative Societies?
Yes.
Please get instructions in this case.
Please.
Whether the entire amount is paid by him or not, basing on that, whether he is acquitted it is a submission of the Land Council to the petitioner that the entire amount is paid. And when earlier when
There is a finding to this effect from the civil court.
Huh?
There is a finding to this effect from the civil court.
Civil court, not criminal court.
Criminal court.
It is stated that the proceedings that are initiated by the respondents under the Negotiable Instruments Act were closed by the criminal court, observing that the entire amount is paid. Without suppressing all the facts and without taking note of all these facts, the award is passed by the second respondent. Yes, the AGA shall get specific instructions in this regard, list on Thursday.
Yes, my lords, copies are not served. Copies are.
Sir.
No, there is no rule that you have to serve the copy on the government when they are
Since
available.
officer has not raised objections.
It's all futile exercise. No, when the government, he is appearing for the government, unless and until their office seal is there, first of all, the writ petition shouldn't be numbered. Yes. It is a different fact, even if papers are served, whether they get instructions or not. Yes.
Seal number 17. 30 minutes.
Petitioner is the JDR, my lords. Petitioner is judgment debtor, my lords. Respondent is the decree holder, not. Respondent filed a suit for specific performance, and there is an order for refund the amount, my lords, with interest, my lords. The respondent filed the execution petition, my lords, along with IA for attachment of the property, my lords, and both have entered the compromise. 23,80,000 my lords to pay.
but JDR is unable to pay within 4 months, my lords. So he has filed an application for extension of time, my lords. It has not been considered, and I number 1 is for attachment of the properties order, my lords. During that period, my
When was
lords,
the decree?
on 10/4/2017, my lords.
So early. And still you want time.
No, my lords.
10/4/2017 is the
And also
decree.
he appeared before the Honorable High Court, my lords, by filing RFA, my lords. He withdrew the petition, my lords, appeal.
When was your RFA dismissed?
My lords.
When was your RFA dismissed?
RFA dismissed on 2025, my lords.
2000?
My lords. He withdraw the petition, my lords. Decree holder. And
Come to your IA. What is that you sought for?
Annexure G is the impugned order, my lords.
Annexure?
G.
Not the impugned order, your IA. Your affidavit.
IA for extension of time, my lords.
Where is that?
Annexure B, my lords.
Page number?
Page number 14.
50?
Annexure F, my lords. Page number 19. I number 2. Lords,
Kannada.
please, ma'am. During
Come to
that,
the-
my lords, during
Come to the
that,
impugned order.
Annexure G, my lords.
Hmm.
Page number 20. Operative portion, my lords. 34, my lords.
No, where is the discussion about court also imposed costs of?
IA number 3, my lords.
Huh?
On IA number 3,
Where is the discussion?
not
This is an order. Where is the discussion?
about IA number 2, there is no discussion, my lords. They have not considered, my lords. IA number 2, my lords, for extension of time.
No, I'm not able to understand. This is the only paper you have filed.
No, that is order sheet, my lords. Annexure G, my lords. Annexure G. There is a
Not an
detail order.
sheet.
There is
This is not an order sheet. Order pronounced in the open court, white separate order.
Alla,
Where is that
there is
order?
Page number 34, my lords. Annexure G. There is a detail order on IA number 1.
30?
Page number Annexure G. Page number 25 to 34.
Let's read this.
Please.
Come to the reasoning part. Para 11.
Para number 11, my lords.
Hmm.
Point number 1 and these are 3 points are interconnected to each other and they are taken together for common discussion to avoid the repetition of facts. Admittedly, certified copy of the decree reveals that DHR has filed the OS number 257 of 2016 against the JDR seeking the relief of specific performance of contract. The said suit was decreed on 10/4/2017, my lords, and directed the JDR to pay 12 lakhs amount with interest at the rate of 14% per annum from the date of the sale of the agreement, that is on 19/10/2015 till its realization. After the institution of this execution proceedings, there was a settlement entered in between both DHR and JDR regarding the payment on 19/8/2025. Both the parties, learned counsel for the DHR and JDR, filed the joint memo, my lords. As per the terms and joint memo, the JDR was agreed to pay 23,80,000 amount to the DHR on or before 18/12/2025, my lords. On one-time settlement. In spite of said settlement, the JDR could not come forward to pay the settlement amount. There is any order from the Honorable High Court to stay the further proceedings of this matter. Admittedly, the appeal preferred by the DHR was withdrawn as dismissed, my lords. Go through the application schedule and copy of the property register card furnished by the DHR reveals the CTS number so and so situated at so and so is in the name of the JDR. Further, it reveals that there is no joint name of the third party application in that property extract. Learned counsel for the third party
So
applicant.
your wife will file an application under Order 21 Rule 97?
So some amount has been
No, you will file an application for extension of time.
I have filed early, my lords,
That's what
for
I'm
extension
saying.
time.
Your wife will file Order 21 Rule 97.
Please, no, some amount
So
has.
that shows that there is no bona fide on your part.
No,
to
my lords, my mother
pay the
is
amount.
actually my mother is expert. I have produced the document.
Why
but
should
that's-
your wife file an application under Order 21 Rule 97?
So some amount has been transferred to.
Please come.
Some time to requirement to consider my
Absolutely
application.
no bona fides on your part.
Lords,
Agreed with
extension
all
of
this
time,
part.
lords, to settle the amount, lords, some time.
At least I can understand. I thought you only asked for extension of time. I thought I would
I
grant
filed
it.
and that application has not been,
When your wife files a petition under 2197, that itself shows that you have no intention to settle.
no, my
In a
lords,
settlement, how can anybody file this petition?
I filed an application that application is not been considered, my lords.
Which application?
I number 2 for extension of time, my lords.
Then what is I number 2? What is your wife's petition?
They have filed third party application, my lords.
Not necessary.
Lords,
The present petition.
sometimes, my lords, to consider
File an affidavit before this court.
that application
File an affidavit before this court. Then I'll grant.
Monday, my lords.
Does this matter on Wednesday?
Please. Orders matters.
Matter today is, there is a
Wednesday it will come.
matter today is before the trial court for attachment of the property.
List this matter on Wednesday. By that time, there shall be an affidavit stating that an undertaking affidavit before this court when the petition is going to pay the amount. Till such time, no coercive steps shall be taken. On Wednesday, if the affidavit is not filed, the writ petition will be dismissed on the ground.
Please.
Yes.
Orders matters, seal number 18.
Notice to the respondent. Take out handsome take out handsome and shall file a memo to that effect by Wednesday, by Tuesday. Yes. Yes.
My lord, short recommendation. We recently received the NOC, so need time to comply.
18. Steps shall be taken within a period of 10 days, or else the writ petition shall stand dismissed without further reference to the court. Yes, 19.
Seal number 19.
Respondent.
Look at it if interim order is there, extend. Yes, 19.
19.
What is this?
The challenge is to the registration of a society, which was done in the year 2020, after a lapse of 4 years.
Where is the counsel for the petitioner?
He's seen online, but Sri Prasad.
Joras Patil.
Raviraj C. Patil.
Sri Prasad,
Sri Prasad J. Joshi. Sri Prasad. Sri Prasad is here. Sri Prasad, submission ಮಾಡಿ.
So, as per the instruction by the standing council, my lord, matter may be taken up next week, any date, because he is suffering from ear and throat infection.
Submitted that the counsel for the petitioner is unwell. Does this matter on Thursday?
Very
please.
First, 19.
The interim order is there.
Interim order.
20.
In this matter, I
Seal
appear
number
for the
20.
petitioner, my lord. It may be taken up on Monday, my lord. By the time I'll amend the petition, my lord.
Let's this matter next week by the time the amended petition shall carry out, petition shall carry out the necessary amendments.
Which may request on Monday, my lords.
Monday, I'm not sitting.
Please, Wednesday.
Yes, Wednesday.
Please.
Obliged.
Seal number 21. Sadiq and Budwala. Dinesham Kulkarni.
Petitioner. In page 5 is my prayer.
Where is this, why this affidavit of assets and liabilities of respondent? Respondent is the wife.
Wife.
What is the order impugned?
In page 43,
How much is granted?
30,000.
30,000 to the wife and the child.
Yes.
What is your income?
My lord, that is, my lord, kindly turn to in page 48. The reason for the enhancement. My lord, reason is recorded that I am in Germany. I was getting, my lord, salary about 35,000, 65,000, 35,000 in year 2017. After lapse of him might have been getting 1,50,000. Therefore, it has been granted.
Where are your statement of assets and liabilities?
My lord, I have not filed.
Then adverse inference has to be drawn as per the judgment of
Rajneesh versus-
versus Neha.
One more.
At least after coming before this court, you would have find if there are any bona fides in your request that I'm not earning and I can't pay this 30,000. But you have not. First step 1, you're supposed to file. If not, Honorable Apex Court said adverse inference has to be drawn. Whatever is the requirement of the wife, it should be granted. That stage is over. Now we have come before the court. At least you would have filed before the court.
Yes.
You have not filed.
Yes,
Well, I will confirm this order.
one request, my lord. Now the interim maintenance is, my lord, I had filed, my lord, a petition for divorce.
Petition for?
Divorce. Divorce decree is granted. She has filed for setting aside miscellaneous, my lord, setting aside the ex parte order. In that, my lord, interim maintenance is granted. Interim maintenance is granted,
How much?
about 10,000.
10,000.
Yes. This is 30,000.
While granting 10,000, court has taken note of this order.
Please, my
This
lord.
is subsequent order. The court said till the disposal of miscellaneous petition.
Then it will go.
Well, lordship that clarified and disposed.
No, how can I clarify in this?
Because, my lord,
How
she
can
is
I-
claiming both. One.
No. When the court said, where is that order?
That order, my lord, last time I had submitted.
They're residing with her parents.
Not that. In the miscellaneous petition, what is the order passed by the court?
My lords, in the miscellaneous petition, the order passed by the court is to pay interim maintenance of rupees 10,000 till disposal of criminal miscellaneous
When
case.
you are
my lords.
having already 30,000.
Before passing that order, we have already filed criminal miscellaneous petition, my
So
lords.
what we do, what now? Now you are not entitled for the criminal miscellaneous, already you are having this. On that ground, I'll confirm this.
My lords, the thing is,
You
the wife
can't
is.
have multiple
Please,
maintenance.
I agree, my lords.
And at least I can understand in this case, court has observed that already you are getting 10. Along with the 10, you are entitled for another 30. That makes,
Please, my lords.
that is not neither it is observed here nor there.
My lords, the respondent has not filed objection in the criminal miscellaneous case, my lords.
Whatever it is, if you want this court to confirm this order, you have to get instructions from your client.
Please,
What
my
that
lords.
10,000 you should forego in the light of this order.
My lords, the wife is, the wife is maintaining the minor son, my lords. The husband is not paying single
Have the
penny, my lords.
maintenance in either there or here or some amount. And without a mention to one order, you can't have this maintenance, criminal miscellaneous 30, another where, another 10,000.
Please,
How
my
is
lords.
it?
Yeah, he has not paid a single.
That is a different aspect. That's a
In
different aspect,
criminal
whether he has
miscellaneous
paid or
matter.
not. That is a different aspect. You have to tell the court by way of an affidavit before the court, saying that because in the light of if this order is confirmed, I am ready to forego the 10,000.
Please, my lords.
If you file an affidavit, I'll pass orders. List this matter on Thursday.
Please. Lords.
Thank you.
Yes.
Bill number 22, Girish Dharwad.
Before the petitioner, my lords. This is a case where, my lord, the petitioner requested for change of name in the birth certificate. My friend, my lord, for the respondent is online.
Yes,
My
my
lord,
lord.
yes. This initially, my lord, suit was instituted.
What is the age of the petitioner?
He was born in 2014, now 11 years old, my lords.
I have reserved one matter.
In fact, yes, my lord. I have also produced copy of one reported judgment of this honorable court which covers this, my lord, issue, page number 36, annexure E.
Justice,
Sanjay Gowda's order, my lords.
But I have already reserved one matter. I'll
In this case, if I may, my lord, seek leave of this court, there is some urgency. That's why I requested for this date, my lords. Because he parents, my lord,
Even in that case also the same urgency.
Yeah.
We will. Yeah, list this matter along with that number. One is there, birth certificate, one look at it. Yes, both the matters, heard reserved.
my lords are taking a different view, my lords, or my lord, no, because I wanted to.
Whatever you would have explicitly.
In that case, my lord,
On submission, my lords, in this matter, the registration of the birth took place 11 years ago when the child was born. But
That's the
the
whole issue. Now, there should be a provision to them to do
Yes.
it. I can understand within, if something has affected somewhere in a suit or somewhere, if the same communication is sent to them, doing it. No, by asking them to do all this, and at the same time, the other party can't be remediless. So for that reason, I've reserved it.
yes, my lord. In this case, what happened is, my lord, pursuant to this judgment, my lord, we submitted representation along with an affidavit as, my lord, required in that judgment. The only say of the respondent is that, my lord, you should get a court order to get, there is no dispute regarding, my lord, why the name is to be changed or anything. It's only, my lord, that earlier he was named as Krishna.
Can be how are we concerned with all this? No, you have to go to the court. There should be some basis for that. No, even examining that, whether they are bound to do it, if they are bound to do it, what should be the procedure? There should be something. There can't be an order on case-to-case basis.
Yes,
There
yes,
should be a
ma'am.
direction to the respondents. For that a general, earlier I have, when I was in Telangana, there was a case where in a birth certificate, if you have to enter, you have to have a birth certificate. You have to have the caste and religion have to be mentioned. Without that, you cannot have a birth certificate.
Yes.
Then for each party who comes to the court, we can't pass an order. Then I have passed an order when the constitution gives them the right to profess their own religion, it equally gives them a right not to do it.
Yes.
So in every portal, there should be one option to say no caste. So there should be some, the solution to a problem, not independent.
Yes, ma'am. With due respect, ma'am, so far as non-availability of provision, my lord, that has been taken care of by this judgment.
I'll see.
Which that for itself, my lord, that it's for the.
If actually there's a Sanjay Gowda's judgment covers what all I am also feeling, it's fine. If not, if I need to add something.
So far as,
or
my
if
lord,
I'm
this
not agreeing
present
on
case is
something,
concerned, my lord, there are no other disputes. That's why, my lord,
if I'm not agreeing on something, it's a different aspect. If I'm agreeing on all the things, same will follow. That I want to examine.
only request, why, my lord, school require.
It will take a week.
Yes.
Yes.
It's a transferable job, my lord. Therefore, there was.
It takes. Yes.
Milords, a humble 2-point submission on the matter.
My friend.
Milords, in this instance, there is the limitation of, because the petitioner had sought declaration from the Honorable Lower Court. The Honorable Lower Court held that the time period of 3 years has elapsed. Whereas the judgment that has been supplied by my friend, it says that even adults can go in for change of name at a particular point, whereas the statute itself prescribes 15 years limitation from the date of registration of the birth. You know, my humble
Examine all
submission.
these aspects.
That one
Yes,
issue, Murad, so far as Murad limitation, in this case also the petitioner had first instituted a suit seeking Murad declaration of change of name. Trial court said that Murad, you are come to the court beyond 3 years, therefore it's beyond limitation. But the act provides Murad limitation up to 15 years. My friend is.
You can place your written arguments also. Give it to the court.
No, nothing more. In this case, in fact, that's what I am submitting. There are no disputes. Even the authority would not disagree for more change of name.
There are no disputes. When
Yes.
there is no provision under the act, when
Yes.
we are doing it, you have to do it with some source of.
Yes, yes, ma'am. That's why my request would be to direct them to change the name.
I should be satisfied. That's what I said.
No, there,
Yes.
if Murad,
Sir, yes.
Number 23. Sharath ji.
Day before yesterday's matter, my lords, I'll file written arguments.
Take that. That matter also reserved. Yes, next. 24. We'll pass on.
I have a.
You also want to file written statement?
No, my lords. I have submission, lords. I'll complete in a couple of minutes, my lords, on certain aspects.
Better you give the written arguments.
No, my lords. It will take not more than 5 minutes.
No, already his written arguments on record. You also give. I'll pass the orders. Give it to the court.
In 2 to 3 minutes, my lords.
I can understand your written arguments also. Let's not go. That's already I heard enough. I remember all the facts.
No, my lords. In 3 minutes, my lords. Please, my lords.
Why not? Why not your arguments by written arguments? What court can understand by your argument now? Written arguments also I can understand.
My lords, I just highlight the page numbers, my lords. That's all my duty.
Then I it on a paper. Better. Yes.
Lords.
Give it to the court officer. Yes, next 25.
My lords, till then interim order may be.
Nice. Yes. Interim order shall continue till then. Yes.
Seal number 24. Umesh Udemani, Shopa.
A week's time, default order.
Umesh.
Yes. 25.
Seal number 25. इसके कायक मत.
My lord, the office has raised objection in mental ability. Appeal by the initiator 173 subclass 2.
It is the office has raised the mental ability and under light of under section 173 2 as the value of the appeal is less than 1 lakh, land counsel for the insurance company submits that the insurance company is on the ground of
Another passenger in goods vehicle.
liability, and once it is on the ground of liability, the appeal is maintainable. Yes.
I may request to post along with connected matters.
The objection with regard to the maintainability is overruled, just along with so and so.
May I request a date next week?
Huh?
May any date in next week, my lord,
For what?
along with other matters for admissions.
They'll come. Yes, 26.
Seal number 26. Santosh Kumar.
Bank account has been frozen by the cyber cell. Petitioner is a my lord, payment gateway company, just like Google Pay and
Instructions, requires a further instruction.
That is what it is adjourned.
Yes.
AGA. Then an additional government advocate who accepts notice on behalf of so-and-so as to whether any crime is registered against the petitioner.
I have communicated but not received instruction.
Who is that?
Please.
To whom you have communicated?
That's the respondent number, my lords.
First respondent.
First respondent.
Cyber cell, my lord. There is no crime registered, my lord. It is not reported to the magistrate also.
This court on 6/2/2026 has passed a specific order directing the additional government advocate to get specific instructions as to whether any crime is registered against the petitioner, whether the same is brought to the notice of the magistrate. If it is brought to the notice of the brought to the notice, before which court the matter is pending, so that the petitioner would be in a position to file an appropriate application before the concern. It is submitted that it is communicated to which to whom?
First respondent.
Town police.
Town police.
The first respondent. How can the inspector will represent the state?
Lord, that is the cyber cell is with them. That is.
You should know.
Yes.
State will be represented by the principal secretary. No, you have to make him as a party, as an inspector, so and so. How can he will represent the state? That you can't array him like that.
Yes.
It is submitted that respondent number 1 is already informed. The AGA submits that the respondent, it is informed to the respondent, but he has not received any communication from them. It is so unfortunate that when the court has directed when the court has passed an order on 6/2/2026 and directed the AGA, and in turn the AGA has requested the first respondent to get the information, to get the relevant information. In spite of that, the information is not given to the respondent. It shows the conduct of the first respondent. The first respondent shall be present before this court with all the relevant details on Tuesday.
Please.
From now onwards, Mr. AGA, tell everyone, whoever doesn't give you instructions, he shall be present before the court.
Obliged.
Number 27.
This matter was earlier. It was heard, my lord, along with some other matters. Today they are listed at
Yes.
230 list.
2:30, but I'm not taking up the 2:30 matters today.
Here, my lord,
I'll hear this independently. Yes, what is it?
Yes.
Where is ask the AG to come? You be here. Once he comes, I'll
Please.
call the matter once the AG comes. Yes, 28.
Number 28.
Have you informed them that I'm not taking up? Yes.
No, I have challenged the ballot paper, election ballot paper, in that the symbol is, as the respondent number 2, election officer.
What is the remedy available to them?
No, as per the bylaws produced by the very petitioner, election tribunal is there. There the parties can challenge the results, but not at this juncture. Having contested and filed a nomination, and he was also a prospective candidate for the prospective coming elections, wherein the ballot paper may kindly be seen. The main contention is that only particular instrument has been shown as a symbol for the particular group of people. The grievance is that they should have been independent symbols for each of the persons.
How can two symbols be given to two candidates, different candidates?
Groups are there. They themselves have come forth with in a group way. They are coming before the election officer. The election officer has not taken any personal initiative either to grant or not to grant. The entire process.
Please understand, there are two different groups. For the two different groups, only one symbol will be allotted.
No, man. One diamond is one group is
For
given.
saying, I am only understanding from what you said.
No. My submission is that along with the symbols, there is photos of the candidate is available. Their grievance is that.
Symbol be given, and that's what I'm asking. For example, first so and so comes, you give a symbol to them. Next, the second person comes and asks for the same symbol. Or say that I'm-
Groups of people in previous election also, earlier elections also, they used to come as a group. It is a managing committee elections of the Waqf institution. No general election. 5,057 voters are there. All those persons are known to one and another. It's not the fact that something else is being made or somebody is given a.
I've only asked you a simple question.
Please.
Whether it's general election, whatever election, high court election, advocates association election, whatever election. What is the purpose of giving a symbol?
To identify the person as the candidate.
So why should two persons have the same symbol? That is simple common sense. Let's not go into law at all. Simple thing. Now you have to vote. Now while voting, people will not look at now the symbol. That's what the whole purpose of the symbol is. That not that because they know the face of the candidate. If they know the face of the candidate, why are you giving them the symbol?
No, their photos are also printed on the ballot paper, my lord.
There should be some application of mind by the concerned returning officer. And it is a genuine concern. When something which can be avoided at a threshold, you don't avoid it and say that you file an election petition.
No, that it's as being directed by the court. I have secured the information and presenting before the court.
Consider it. Two people cannot have the same symbol. Why do you confuse the voters? What is the relief you are seeking?
Cancellation of the very election process itself.
I'm asking for the
Entire ballot paper.
Questioning the ballot paper and symbol.
When was when this came to your notice? No, the purpose of the candidate should not be coming to the court and seeking the stay of the proceedings. When was it in your notice? When did you know that two persons are having the same symbol? You must be campaigning for this. So you are knowing it from a very long time?
Yes. No, my lords. 4th, I have received it. Then immediately I have given, along with other 14 general members, we have given objection to the concerned ballot paper. He has not observed our objection. So as per Annexure G series, I have produced it. G4, I have given it to the respondent number 1 also regarding this complaint. So they also now not considered my application. So I have come before this court, Your Honor.
The calendar of events has commenced as far as 21/1/2026. The allotment of symbols has taken place on 2/2. Allotment of symbols has taken place on 2/2.
Where are your representations after 2? Second?
G series, ma'am.
Tell me the number, page number.
Page number.
On 4th, he files an application seeking for the certified copy of the bylaws.
Page number 69 to 73.
Page number 60?
69 to 73 minutes.
When was it
Well,
given?
page number
What were you
six-
doing from 2nd to 7th?
My lords.
What were you doing from 2nd to 7th?
The petition is being filed on 10th, my lord.
Second, 4th, they have received, they have given it. And 7th, again, the petitioner has given.
You should have waited, when is the election?
15th it is there, my lord.
So you could have waited till 17th and then come to the court.
No, my lords, I have filed immediately on 7th also I have issued an endorsement application to the Waqf Tribunal. Then I filed here, my lord.
We'll stay the election.
Please, my lord.
Stay the election. Because that is the understanding of your returning officer or the chief election officer. We can't help it.
No, my submission would be, my lord.
What is he doing when there is a representation given? Is it not his duty to look into it?
No, at that faggot, the symbols were allotted in the presence of all the candidates. It's not the fact that if he was not present before at the time of allotment of symbol, he has no right to agitate thereafter. My first submission. On
2/2,
he's expected to be there while allotting the symbols.
He was there.
What
But
prevent?
about forgetting about their presence, when the same symbol be allotted to two candidates, that is the lookout of the returning officer, isn't it?
No, the document which the petitioner has produced before this court, my lord, on an earlier occasion, the groups were contesting the election as a group.
No, my lords.
Group of people.
As per annexure E,
Your lordship could,
What a request, my sincere request to the advocates would be, to whomsoever you are appearing, you are an officer of the court. First of all, the duty of any advocate is to assess the court. So whatsoever action or any illegality that is done by your party, before that you should answer my question. I asked a very simple question. Presence of the parties and all you forget. Returning officer, will he give the same symbol even if the parties, all the parties say, give me only one symbol, he will give? They accept it. Let's assume that they accept it. Then he will give same symbol to all the parties? Yes or no?
I can't say anything
How can
for
you-
the reason, my lord, the records which the petitioner has produced.
Please come.
Please, my lord.
The presented petition is filed. Sing the following prayer.
My only request, my lord, I seek some time to file objection. That time may kindly be observed, my lord.
The petition is before this court, questioning the action of the returning officer, that is respondent number 2, in allotting two common symbols to the two groups. Immediately when it came to the notice of the petitioner has approached the respondent by giving several representation. According to the petition, it is in their knowledge on 2nd February. And it is a grievance that the respondents have not attended to the complaint given by the petitioner. Learned counsel appearing for
R1.
respondents. Respondent, only one.
I was directed to take instruction from respondent number 1 because I have no instruction as far as 2 and 3 is concerned.
Respondent number 1 submits that whenever on 2nd, when the symbols were given, all the parties were there. The petitioner has not, had the petitioner raised an objection, as the petitioner has not raised any objection, it is not open to them to raise this objection at this time. It is submitted that if the petitioner has any other grievance, it has to be decided in the election petition. And at this stage, they cannot raise any dispute in this regard. It is submitted that if some time is granted, he would be filing his objections. Next part. This court is not able to appreciate any of the submissions that are made on behalf of the first respondent. The whole purpose of giving the symbols is for the identification. By giving two same symbols to two different groups is in a way not in the is contrary to the very purpose of issuing the symbol, and the objections ought to have been considered at the earliest. In that view of the matter, there shall be stay of
annexure E2.
When is election?
15th it is there.
There shall be stay of the election to be conducted on 15 to
2026.
The petition is permitted to take out hand summons on site respondent number 2 and 3 and shall file a memo to that effect by 23rd of February. List this matter on 24th.
One more submission. In view of the election being stalled, the board has to take some steps to see that the institution run. For that may kindly be made clear, my lord.
As per the framework under the Waqf Act, the affairs of this, there shall be, what is that called?
Administrator.
An administrator shall be appointed.
To take care of it, please.
Hearing on IA. Number 29.
The list is matter before another court. Why, in spite of giving a note, why they are posting? Ask them. Ask them and ask them to come to the chamber. Every day, the same thing they're repeating. Yes. Yes, 30.
Number 30.
Appearing, my lords, for the petitioner. Challenging the annexure L, my lords. Which is the petitioner, my lords, or the third party obstructors, my lords. They, my lords, have filed an IA for under order 21 rule 97, my lords.
What is the suit for?
Suit, my lords, is for permanent injunction and mandatory injunction, my lord. They are not the parties to the suit, my lords.
I understand.
Please, it is suit for permanent injunction and mandatory injunction.
Decreed.
Decreed, my lords. JDR 1, my lords, and 2, they have filed an appeal, my lords. Appeal dismissed, my lords. As against that, my lords.
What is the relation between you and the JDR?
Lords, JDR, my lords, is my senior uncle, my lords. I am having independent right in the property, my lords. Even though he is a senior uncle, my lords. DHR is the respondent 1, my lords. JDR, my lords, are not represented here. JDR.
Injunction is against the defendant.
Please, my lords. Is against the defendants, my lords, who are my senior uncle, my lords, senior paternal uncle. And in that they are not contested properly, my lords, and the suit came to be decreed. Subsequently, they have filed a regular appeal, my lords, and even regular appeal got dismissed. As against that, the DHR, my lords, filed a EP exit. EP, my lords, they have filed, my lords, for mandatory injunction to cull down the property, my lords, which is built on the property, my lords, which is allegedly earmarked for the parking space, my lords. There's the allegation, my lords, is that it is a layout plan, my lords, which is approved by the Buddha, and it was earmarked for the parking space. And as against that, they have filed a suit, my lords. They have not made me as a party, my lords.
Let's see.
Please.
Where is impugned order?
Impugned order, my lords.
Which number?
Page 117, my lord.
107, my lords.
L.
Come to the reasoning part.
My lords.
Para 24 onwards.
20, 21, 22.
20?
20, 21, 22.
Let's read 21. 20.
Please. Having referred to, may I read, my lords?
Yes.
Having referred the aforesaid decision, it is quite essential point to note that if any application filed under order 21 rule 97 or 99, there is no automatic inquiry and the court must examine whether the inquiry is required to conclude the factual aspects of the matters or concern. Therefore, this court, without taking such detailed inquiry, moved to decide the application on admitted facts and circumstances of the case is concerned. With this background of this matter, I would like to refer the documents relayed by the third party obstructor. According to the third party obstructor, the third party obstructors have got a right in and over the petition scheduled property through the legal heirship of Srimati Mehboob B, and by virtue of the decree passed in OS 217 of 2007 and RA 15 of 2012. It is in this regard I have carefully perused the judgment and decree passed in the OS 217 of 2007. Admittedly, the property bearing TS number 940/1, old survey number 523/C/3, which is consisting of open site measuring 4.93, and it was item number 5 therein. The description of the suit property in OS 217 of 2007 enunciates that the property so claimed by the parties in the said suit was then the open site measuring 49.3, which comprises in TS 940/1. With this description of the property referred by the parties of the OS 217 of 2007, I would like to take the note of the hand sketch map relayed by the decree holder in the original suit along with the plaint. The decree holder had not put any claim over the property bearing TS 940 with regards to ownership as well as the possession. It is only concern of the decree holder regarding the construction put up by the judgment debtors in DEFG HIJK portions earmarked at the hand sketch map with ABC portion. According to the pleading set forth in OS 475/2006, the said area is meant for parking of the vehicles ingress and egress to the property of the decree holder from the main road situated on the eastern portion. The court, having considered the dispute of the properties on the merits, concluded that the defendant should remove said obstruction caused in the property earmarked at the hand sketch map annexed to the plaint. On conjoint reading of suit item number 5 described in 217 of 2007 and the property claimed in OS 475 of 2006, what it appears is the decree holder's claim is with reference to the parking place and the road to reach his property of the main road situated on the eastern side. No such claim has been put forth by the plaintiff to the title of the property belongs to the judgment debtors is concerned. 22. In addition to the judgment and decree in OS 217 of 2007, the attention of this court would upon the judgment and decree passed in RA 9, 10, 15 and 2012, which were preferred by Abdul Ghani, son of Basha Saab, and Abdul Hai, son of so and so, wherein the Honorable Appellate Court was pleased to come to the conclusion that the judgment and decree passed in OS 217 of 2007 by allotting 1/17th share to the plaintiff of the said suit was not correct, and accordingly the Honorable Appellate Court was pleased to allow all the three appeals filed before it in part. While allowing so, the Honorable Appellate Court was pleased to held as unterminous. Consequently, consequently, the judgment and decree passed in OS 217 of 2007, dated 23/2/2012 by learned principal seniors is hereby set aside, and decreed the suit of the plaintiff in part in the following terms. It is hereby declared that the late Mr. C. Basha Saab, father of the plaintiff, defendant 1 to 6, defendant 17, late Sri Muhammad Ali and late Sri Muhammad Saleha alias Ibrahim Basha together held a suit items 1 to 4 of the properties in jointness are entitled to 1/8 share each in all suit scheduled properties. It is hereby declared that the plaintiff, being one of the daughter.
We come to paragraph number 24.
Please, my lord. The third party obstructors have maintained the instant application stating that they have got share in the property bearing TS 940/1, which is measuring 49.3 cents, and their claim is based upon the judgment and decree passed in OS 217 of 2007, which was modified in RA 15 and RA 9 of 2012. As is extracted above, the observation and the order of the Honorable District Court passed in RA 9 and 15, no such share has been allotted to either to the third party obstructor, judgment debtors, or anyone claiming one Mehboob B in the suit scheduled property, my lords. My lords, the decree, my lords, passed in RA 9, my lords, is produced, my lords. My lords, may kindly see at page number 60, my lords.
60.
Please, my lords. In OS 217 of 2007, please.
Show it and then submit.
Please.
What is the name of the parties?
Please, it is, my lords, in.
Let's see the name of the obstructor.
Instead of in my.
Haider Ali,
Please, ma'am.
Muhammad Nasirul Hussain.
Please,
Both.
ma'am.
Please show these two names.
Let's, firstly, OS 217, my lords, which has granted, my lords, I'll show that, my lords. Page number 30, my lords, may kindly see.
Page number?
30. It's a suit, my lords, OS 217 of 2007.
Page number 30.
Please, my lords.
This is the decree. This is the.
Suit, my lords. First,
Where are you?
My lords, the JDR 1, my lords, is 2, my lords, Mohammad Sadiq.
No.
My is it 31, my lords, 3D, Haider Ali, C. Haider Ali.
1 minute. 30?
31 D, my lords. In D, his name is shown, 3D, Haider Ali. The property, my lords, is shown at 36, my lords.
Then
36, my lords.
where is the other one? There are two petitioners here.
Please, my lords.
One you have shown, Haider Ali. Where is the other one? The other one is Muhammad Nasir.
Please,
Where
ma'am.
is he? Muhammad Nasir, son of late C.A. Ghani.
Please, my lords. I cannot see. Once.
He's not there.
No, he's there. my lords.
Hmm?
AC Gunning. He's there. One. Sorry, my lords. His father is there, my lords. His father is there.
Where is he?
At 4, my lords. Abdul Ghani. My lords, may kindly peruse 36, my lords.
30?
36 page. Wherein, my lords, the property at the starting it is shown, my open site measuring 49.3, my lords. This is the property, my lords, in which the share has been granted.
Come to the decree.
My lords.
Where is the decree?
Decree, my lords, judgment is produced, my lords. The order, my lords, will find at 54, my lords. OS order.
Photos. Continuously, the nuisance is going on in the court. Please look into that. 50?
54, my lords.
Yes.
It is further ordered that the defendant 6, may I read, my lords? 54. It is further ordered, my lords.
Where are you reading?
54 starting, my lords, page number 54.
It is further ordered.
It is further ordered that defendant 6 and 17 are entitled to share in the suit properties to an extent of 117.
Your defendant number, this is
3, my lords.
referring to the plaintiffs.
Please, my lords. In the next part, my lords.
Defendant number 6.
My lords. In the next part, my
Defendant number 6 is Sabira Begum.
please, my lords. In next part, it is written, my
15
lords.
is somebody else.
In the next part, it is written, my lords.
Defendant numbers 1 to
5 are entitled to 17th share each.
2 by 7 share.
2 by 17 share, my lords.
Then
Subsequent
what has happened to the RA?
RA, my lords, what has happened? This property, my lords, is a mother's property, my lords.
What happened to the RA?
In RA, my lords, this property is shown in the
Where is that
my
decree,
lords.
judgment?
Judgment is not produced, decree is produced, my lords.
Where is that?
Page number 60, my lords.
60.
Please, ma'am. The cause title, my lords, is at page number 56.
Yes.
The name, my lords, may kindly be seen at 3, my lords. The Hyder Ali.
So what did the decree say?
What, my lords, has happened? The item number 5 is not at all considered, my lords. Because item number 1 to 4 has been altered, my lords. Item number 5 is not altered, my lords.
Could you please point out from the order?
It is hereby declared that the defendant 1 to 5 are entitled to 217 share each. Defendant number 7 to 13 and 22 are entitled to 217 share, and defendant 4 are entitled to 217 share and 1/8 share of late C. Basha Saab in all suit item numbers 1 to 4 properties. It is hereby declared that defendant 3A to K are entitled.
We'll read from here. It is declared that late C. Basha, father of plaintiff, defendant number 1 to 6, defendant number 17.
Please, my lords.
Has
It
the
is
suit schedule item number 1 or so
in jointness and entitled to 1/8 share each in all scheduled properties.
Oh. Yes, Mr. Counsel. Now this defendant 1 to 6, these two petitioners to 2 obstructors will also form part. And what is observation of the court that they have never, no property is allotted to them?
Even assuming that those in item number 5.
Assume something. Now
please.
he is before the court questioning the order of the trial court.
Please, no.
Trial court gives a finding that they have not got any property under the judgment and decree. Now this makes it clear that they have been granted.
So item number 1 to 4 anta 1 to 4, my lord. Item number 1 to 4. They are claiming property.
Property is
Item number 5, my lord.
item number.
5. In the decree, my lord, nowhere it is stated in the item number 5. In
Item number 5 is given to whom?
no, with respect to that, there is no not the clarity in the because I am not party to the suit filed by the family members.
So the court has interfered with the order of the trial court as far as this item number. So in the item number, what is this item number?
1 to 4, my lords.
Huh?
1 to 4.
Item number 1 to 4. Now let's go back to item number 5 in the original decrees. Where is that?
Please, my lords. 54, my lords. 54, my lords.
What it says?
It is also ordered that the
Properties to the extent of is also ordered defendant number are entitled to 2 by 17 share.
Please, my lords. The shed.
It's about which schedule property.
Schedule, my lords, may kindly see it, page number 36, my lords.
Order should contain in which property you are entitled for.
No, my lords, in all properties, OS granted to me, my lords. In OS code.
So that means in all you are not granted any share by the appellate court.
No, my lords, what, it was unaltered, my lords. 1 to 4 properties, my lords, were the properties of the grandfather, my lords. The item number 5, my lords, was the property of grandmother. And it was unaltered, my lords. No one, my lords, has filed as RA, my lords, as against that, my lords. It was filed only for 1 to 4, my lords.
If you look at the appellate court order, it says that the entire judgment and decree is set aside.
My
It
lords.
didn't say that it is modified.
No, my lords, what has happened, my lords, it was challenged against only properties 1 to 4, my lords. It was not challenged against,
That is the case. Why should the court set aside the judgment and
irrespective of it, my lords, one submission. The RSA, my lords, is pending again in this court, my lords. In 2012, RSA is filed, my lords, and it is pending on the file of this honorable court, my lords. It has not yet been decided, my lords.
My submission is that this, my lord, the ancestor, my lord, the one Mehboobi, who is the grandmother of the, my lord, the present third party applicants and the, my lord, the original defendants in the suit, they have formed a layout, and she has given undertaking to the, my lord, the Ballari Urban Development Authority that this space, my lord, it will be left for the, my lord, the civic community, such as parking and use of, my lord, the easementary, etc. In that property, my lord, property left for the civic community, in that portion, they have, the persons, my lord,
Stay,
Well, it was,
do you have a stay?
yes, ma'am.
This is matter in the month of March.
lordship,
Obliged.
in the property left for civic community, they have constructed, my lord.
It has to be heard at length. Yes,
Seal number
Obliged.
30.
So date may be given,
this is the matter on 18th of March.
please.
Obliged.
Yes.
Seal number 31, Lingaraj.
My lords,
My
the
lordship, I
order
have filed
that
an
has
IA
been
to
challenged.
withdraw the amount. I have filed an IA to withdraw the amount. The petitioner is the KSRTC, my lordship. They have deposited 50% of the back pages of the respondent. Hence,
My
it's my
lords, the
request.
order we have challenged is completely in Kannada. I seek for a short accommodation, a week's accommodation.
She is not asking
My
for
lordship,
hearing
with
the
the-
matter. You have deposited the amount.
My lords, there is
Part of
a,
it, can it be withdrawn by her or not?
My lordship,
my lords,
annexure
there is a
A,
writ appeal pending before the, there is a writ appeal pending before the honorable court. It needs to be adjudicated
Writ appeal against what?
against the
annexure A, my lordship. This writ petition is
which is
preferred against the
order passed
annexure
by
C, my lordship.
labor court, my lords. That is under challenge. It needs
So
to be.
sometimes I get like something is wrong with my hearing. There is a mic before you, you're
ma'am.
submitting, I'm not able to hear anything.
Sorry, my lords. There is a writ appeal pending before this honorable court. Uh, In that we have challenged the order passed by the labor court. That needs to be adjudicated, my lords. Kindly have it on next week.
My lordship, my submission, my lordship on submission, my lordship. This petition is against the order of annexure C. It's in English, my lordship.
Who is next 32?
32. Seal number 32, Lakshman T. Matagan. Prashant.
Petitioner.
Asmani.
Please point as filed in IA for vacating. This contract has been granted to the petitioner herein to the cleaning of the toilets at KSRTC Belgaum. Here he participated in the bid and he is the highest bidder, and therefore it has been given for rupees 5 lakh rupees.
Impugned order dated 25/11/2025.
Yes, 25.
Order.
25 2025 is allegation against the petitioner is that he whatever the contract has been given for collecting 5 rupees from person user of the toilet, wherein it is allegation that he is collecting more than what they prescribed, and so many notices have been served on the petitioner. He has given all the reply saying that it was only because of the previous tenders who have participated earlier tender, who have failed to avail the tender, they made allegations. And further, your lordship kindly see the notices which have been given from
What is the order passed now?
please.
What is the order passed?
Order is that he is collecting, he is not
Tender is
properly
cancelled.
cleaning and also collecting.
His tender is now cancelled for violation of the.
Orders.
Yes,
If
now
the tender is cancelled.
cancelled.
Let's see the tender. Where is the tender? Where is the tender document?
Annexure A, my lords, is the
Annexure
tender.
A is the agreement,
Now, lords, page 10, my lords, is the tender. Now, the violation, one of the terms of the violation, clause violation, my lords, is my lords will find at page 13. Page 13, in that, my lords, clause number 11, in that 4. Now, this is the main charge against him, 4. For each case of overcharging for use of toilet or charging for use of urinals, a fine of rupees 100 per case for first 10 cases, 200 per case for next 10 cases, and the license shall be terminated after 20 such cases of overcharging.
So where is the material for this 20?
Please, lords, we issued him notices. Several notices.
Where have
Please,
you
my lords,
detailed
notices,
that?
my lords, I have filed my.
In how many cases it happened?
Yes, my lords, notices, my lords will find at along with my vacating application.
Your objections, I think.
My lords, he admits that he has the clause by paying fine. Notices were issued, orders were passed that he is that 100 rupees and all that.
Where are your
Please,
objections?
my
Let
lords.
us read your objections to understand this.
No, he produces the receipts
Let
also.
us understand your objections, Mr.
Please,
Counsel.
my lords, along with the vacating application, my lords, I have produced the notices. Notices, my lords will find at page number 10 of my vacating application. That he was overcharging was even published in the newspaper. I produced the cutting of the newspaper also.
Now,
Please.
you have drawn the attention of the court to clause number 11. Clause number 11 is very clear.
Please.
Even as per your own tender conditions,
Please.
but 20 times, till 20 times violation, you will
Please,
not
Lord.
resort to cancellation of the tender.
We cannot.
Now it is for you to tell the court.
Yes.
There are 20 violations by him. Number
Please,
one.
please.
Where are they?
My lords, notices, my lords, at page number 10. It is in Kannada, but what it says is that you are overcharging. We gave him notice. He did not, my lords, improve his, my lords, did not change. Then we have passed the orders also.
He has precluded you to say that is the whole purpose of filing a vacate petition. Bringing the notice of the court, as per clause number 11, this is what it is enumerated.
please.
This is what is a violation. Then your counter doesn't deal with it at all. The land
Lords,
counsel,
my lords, I'll file my objections.
file specific objection, whether there is compliance of rule 11 before terminating the contract of tender of the petitioner. Yes.
Have it, my lords. Next week, my lords, I'll file it.
Next
No?
week.
Please, some date maybe.
Number 33.
May I request, my lord, some date, my lords, I'll file. Because now what has happened is after.
Matter on 19th.
Please.
Yes, 33.
Serial number 33, my lord, I appear for the petitioner. My lord, in this matter, my lord, we have been served with their objection statement and IA for vacating stay recently, my lord, few days ago. My lord, we have in fact given the objection.
I have already served it way back, a week back, my lords, to the council.
What is the writ
My
petition
lords,
about?
my lords, they have challenged the settlement which was entered upon by the petitioners and the respondents before the Assistant Labour Commissioner. Now, my lords, my submission is that to what extent can that settlement be challenged? Because, my lords, under the Industrial Disputes Act, there is no provision to recall or set aside a settlement which has been entered into. Now, my lords, my submission before this honorable court is that, firstly, my lords, this settlement which they have challenged.
They are seeking, what is the relief they are seeking in this writ petition?
My lord,
Lords,
my lord, our entire contention is that the settlement has been entered into by the coercion. That is the all the allegations has been made against respondent number 12. That is the ALC.
Before the
ALC.
court. Then how
My
are you
lords.
going to prove it before this court?
My lords may kindly see the order dated 9/1, my lord. My lord, in fact, they have filed their objections, my lord. We have given it for inputs, my lord, to our circle office. Matter pertains to Hassan and Mangaluru, my lord. In fact, my senior today who argued the matter is not keeping well. If a date may fix, my lord, we will come physically and argue this matter before my lords.
You should have come today.
My lord, he is not keeping well, my lord. That is why he could not travel, my lord.
Lords, may I
This
make,
is matter.
lords, may I make one submission, my lord? Since past 4 months, all the respondents are not going to work because of this retrenchment. Lords, my lords, I am seeking vacating of that stay. Let them. My lords, my submission is let them take them back to the work, and further pending that, let this matter be considered.
Make a reasonable request, not like this.
Please, my lords, I'm requesting, my lords.
They have a stay and you want, without even arguing, without even hearing them, I have to vacate the interim order. What kind of submission is this?
Lords,
Mr.
already.
Counsel? Does this matter on 19th?
Please, highly obliged.
Can be taken up after 21st, my lord, a date,
No,
please.
you have to come on 19th or else I'll vacate the stay.
My lord.
Yes.
Highly obliged.
Kindly be extended, please, my lord.
Yes.
My lord, so this is the claimant's appeal for seeking enhancement to lordship.
Notice the respondent.
My lord, I am seeking an dispensation to the respondent number 1. Notice.
Respondent number 1. Memo is take that or note the notice to R1 dispense with. Notice to the other respondents. Yes, next 35.
Number 35.
Claimant appeal for enhancement. For 1 and 2, it may be dispensed. 1 and 2, my lord.
Memo for 1 and 2 dispense with. Notice to the respondent.
3 notice. For respondent 3, notice may be sent.
Yes, 36.
Seal number 36.
My lord,
Patapati Prashant.
in that, my lord, I1 is filed for dispensation for.
Later. Is 36.
36. Prashant Patapati.
Notice to the respondent.
Notice.
Seeking dispensation of notice to respondent number 2, lordship.
To whom?
Respondent number 2.
To one?
dispensation of notice to respondent.
That's what I'm asking, which respondent?
Respondent number 2, your lordship.
Only two?
Two.
Yes, number 2, dispense with. Case 37,
37, Harish S. Maigur.
notice,
My lords, a trial court records are required, and I am challenging the owner liability, my lords.
them come, let them come.
Seal number 38,
38,
38, Venkatesham Karvi.
Enhancement of the award
yes, sir, notice,
is respondent 1 and 2. Please.
Notice, seal number 39, Gurdeva Gachinmat, Bikanvi.
Denial of passport, my lords.
where is he?
Bikanvi.
There is one judgment, my lords, which I would like to cite.
Huh?
There is one judgment, my lords, where writ is entertained, which I would like to cite.
That is Telangana High Court.
Telangana High Court.
When there is a division bench judgment of our High Court, why should we look at Telangana High Court judgment? We'll follow this, I've already followed. And we'll pass the same order. Because this is not the way you entertain the writ petitions. We can't grant orders like this. When if it is before the civil court, criminal court understands what is it. If there is any flight risk or not, what is it? How can the High Court decide all this?
My
Yes,
lords,
give that-
moreover, my lords, those criminal proceedings, my lords, arise out of, my lords, the
Whatever
complaint
it
that is lodged by the
All the
sister-in-law.
more reason, all the more reason for you. The present writ petition is filed. Seeking the following prayer. Which judgment you're relying on, I'll record that also. Give,
Please.
please give. The present writ petition is filed, seeking the following prayer. It is a case of the petitioner that he is a pediatrician having a unblemished record. And in his professional practice as a pediatrician, he frequently undertakes journeys abroad for the purpose of attending international medical conferences. Petitioner has made an application for renewal of his passport on 6/12/2025 before respondent number 2. But the respondent number 2, by endorsement dated 30/12/2025, has refused to renew the petitioner's passport solely on the ground that 2 criminal cases are pending against the petitioner. It is a case of the petitioner that complaint in the both criminal cases is the sister-in-law of the petitioner. After the unfortunate demise of the petitioner's brother, disputes arose between the petitioner and the sister-in-law with regard to the family and joint property, resulting in a complete breakdown of cordial relations between them. She has also instituted a civil suit against the petitioner. According to the petition, it is submitted that the refuse to renew the passport on the ground that criminal cases are pending against the party. They are violative of Article 19 and 21 of the Constitution of India. As long as the cases he is not the convicted, it is presumed that the accused is an innocent, and as such, the respondents, notwithstanding the fact that the criminal case is pending, ought to have renewed the passport. He had relied on a order passed in the case of Ravi Kanti Venkatesham versus Union of India and another, arising out of writ petition number 32906323, dated 15 December 2023, wherein at paragraph number 9,
May I make one
exact
submission?
paragraph number.
One case, my lords, is it still in crime stage.
one case, my lords. In one case, my lords, there is charge sheet file, my lords, and there is CC. And another case, my lords, it is still in crime stage, my lords. The charge sheet has not yet been filed. So at least to that extent, my lords.
I'll record your submission, 9, extract 9. Basing on this, it is submitted that the application has to be, there shall be a direction to the respondent to renew the application. It is submitted that one case charge sheet is filed, in another case it is still at the crime stage. Looking at the civil disputes between the parties, the respondents cannot deny to renew the passport. Land counsel appearing for the respondent number 1 and 2.
Yes, 1 and 2.
And 1 and 2 submits that. Basing on a division bench judgment of this court, this court has passed an order in WP number 107183 of 2025, dated 28th January 2026, whereby as a criminal case is pending, the court has considered a division bench judgment in Sanjay Kene versus Krishna K, arising out of writ appeal number 200170 of 2022, dated 18/12/2023, wherein the division bench of this court has observed that in cases falling under clause F of section 2 of section 6, even for the purpose of obtaining a passport or renewal of a passport, the permission of the court where the criminal proceedings are pending against the party is required to be taken. The particular shall be taken. Clause E of subsection 2 of section 6 of the Act allows the passport authority to refuse to issue a passport on any or more of the grounds enumerated therein. And clause F is a situation where proceedings in respect of an offence alleged to have been committed by the applicant is pending before a criminal court. And accordingly, the division bench of this court has passed the order directing the party to approach the court where criminal proceedings are pending. Then what will happen in case of a crime where charge sheet is not filed?
After filing of the charge sheet, they can file.
In such time, for example, you
So
take yours.
when, my lord, so when it was within 2 months, they have to file charge sheet. When was the crime was registered date? So till today, it was not, it is within 2 months.
The state is
No, my lord, kindly peruse, it's that passport is expired on 27/7/26, my lords.
Forget about this case.
Please.
I'm asking you.
Please, ma'am.
As a counsel appearing for the respondent,
Please.
in case now, whenever a charge sheet is filed, they'll go before the competent court and seek the permission.
Please, my lords.
Now it is at a crime stage.
Please,
The police will take months together or years together to file a charge sheet. Then what is the remedy available to the party?
Then they insist the magistrate, my lord.
How can they insist?
So,
No proceedings are pending
no,
before-
it is away.
Until, then according to you, they have to go before the magistrate.
Yes, my lord, then-
Questioning I don't think that is the remedy.
So, I will think
What
about it.
you-
I will
you-
think.
you-
Yes,
you-
ma'am,
you
please. I
Come
will
up
take
with that.
Yes.
Then I will, no, because as far as one case is concerned where charge sheet is filed, he'll go.
I will go.
No, for the crime stage, then we'll continue the dictation from there.
No, my lord. So,
After you come up with
no.
the instruction.
Yes, please, my lords.
Keep it, list this matter on Tuesday. Type this. Please get instructions
Please,
as far as
please.
that is concerned.
One more thing is, my lords, if they have not filed within the 2 or 3 months, as per the provision of CRPC, my lords.
No. First, forget about what the police will do.
Please,
You-
please.
What is the relevant passport act, how it deals with it?
Please.
And what is the law in that regard? And how, if not this court, how the other courts have done?
Please, please, I will take it.
Yes.
Grateful.
It's like
Admission matter, seal number 40, engage we Kattemane,
Beneficiary appeal, my lord. Similar order is there.
order
40, 41.
41 also same.
R1 and R2, my lord, government.
Yes. 42.
Seal number 42, Chetan Gunwali, please. Sushant, have order.
My lord, on the previous date, I was asked to file an affidavit. Undertaking that I will not be claiming any equity. I could
Where
not
is
file
that
it yesterday, my
affidavit?
lord. I could not file it yesterday.
Yes. Have you given him the copy?
Yes, madam. I received it. I'll secure instructions in this.
Want to
way.
get instruction?
Yes, madam.
Yes. This is matter on Tuesday.
Please, my lord.
Yes,
May I request
43.
Wednesday, my lord, Tuesday?
Huh?
May I request on Wednesday, my lord?
Wednesday.
Please.
The land council has placed before this court the affidavit as directed by the court. Land council for the appellant submits that he'll get specific instructions in this regard. Yes, next.
Please.
Seal number 43.
Plaintiff's appeal, wherein along with suit, my lord,
I
appeal.
think AG is here. We will take up your other matter.
Please.
Yes, where is that matter? Passed over.
27. Seal
Take
number
that
27.
file. You can take that file.
Yes.
Yes.
Within 2 minutes, I will clarify the position of status of that act, my lord, please. This is a compilation.
No, what we do is first, we'll look at what is the grievance of the petitioner first, then we'll go to the provisions of the act.
No, only if the status of this act, my lord, they've argued that there is a stay of
So
section 20.
that is, he has not argued. His case is not, your case is there. Not 230 matter I'm calling for.
Oh, sorry, sir.
No, it is about his case.
Yes,
A
because-
passed over matter of his same under the
Not-
Endowment Act.
This, in this impugned order is passed by the deputy commissioner, district judge.
No. 59 is at 230, not that matter, this matter. First we'll hear this passed over matter, 101005.
27, my lord, it is appointment of trustees by the
You
respondent.
have the paper?
Please. No.
Take it.
Please.
So what is the relief that is sought to issue a writ in the so-and-so,
Yes. So far as appointment at the category 2,
bearing number, Dharwad, appointing the trustees. What is the district court?
that is those are the matters, serial number 59.
Only one
wherein, my lord,
submission, my lord.
noti-
My lord, this is connected with
No, no,
59 also, my lord. In the event if this honorable court holds that district and session judge has no power, since it's already notified temple, then these petitions will not survive for consideration. So therefore, my lord, my request is,
Which case?
27, what happened, my lord? Here, the respondent number 2, principal district judge, acting as the administrator of a temple, appointed the trustees. So far as appointing at category number 2 is concerned, I am agreed by that because they are not qualified to be appointed as trustees. In serial number 59, the matters covered that whether the district judge can,
Forget about 59. Please argue your
that
case.
yes, it is, my lord, category 2, my lord. Annexure A. Annexure A, my lord, wherein first, my lord, the district shall nominate 2 panchas from resident of Devargutta village. Next, he shall further nominate 2 panchas from among the persons who have endowed the property to the deity, either
Where
in
is-
cash
where
or
is that-
kind.
Where is that page number?
Page number 12.
Page number
12.
12.
It is a scheme, my lord.
Yes.
In a
As per the scheme,
scheme,
2
the-
members shall be nominated from the village panchayat committee.
prior to that, he shall nominate 2 panchas from among the persons who have endowed the property to the deity either in cash or kind. So, my lord, here the respondents number 4 and 5 are now nominated as the trustees under this head.
Four
But
and-
they are not
4
4 and
and
5.
5.
They are
Now,
appointed as
in the
panchayat.
In the nomination, has it mentioned that this is a category under?
Yes,
which is-
yes.
Where is that?
A notification. Lordship, may impugned notification. Annexure F, page number 38.
Yes.
Starts from 38. Your lordship will get page number 45. Category 2, your lordship get serial number 3 and 4.
3 and 4.
Yes, these 2 persons are nominated under category 2. My petitioner's contention is they are not qualified because they are not donors. And endorsement is issued by the authority.
One more clarification.
Please.
From this page number 12,
Please.
what is category 1, what is category 2?
Yes,
Where it is mentioned?
Yes. Your lordship, para 2, your lordship, constitution of the temple committee is as follows.
Yes.
The committee should consist of 10 panchas, of whom Mamledar of the Rana Mennur will be the ex-officer, one person, one member. Appointment of the remaining 9 panchas shall be made as follows.
So the district shall nominate 2 panchas
Yes,
from the residents of the
Yes.
so after consulting such of the local officers.
yes. And 2,
No, so category 2 is this. What you are referring is category 3.
but it is described as category 2 Malu, in the impugned notification. They are described as category 2.
No, how do you, where from?
Page number 45, your lordship.
No, it doesn't say anything.
Serial number 3 and 4, category 2.
No, category 1 is,
Yes,
that we can see. Category 2 is
next page.
two
40 page.
panchas from the residents. So these two are residents of the
Pancha,
village.
yes. And category 2 refers to Dodamani Panduranga Shetty and
Category 3 is what
category
you are
3
referring-
refers to Panchayat members.
No.
Yes, in the next paragraph, your lordship. 2 members shall be nominated from village Panchayat. It is not in consonance with, please.
First of all, you have to understand
Yes,
what is
yes.
the, what is the
No,
framework.
no,
and
my
what is-
grievance is only in respect of these two.
No. First category of people are,
Yes,
the committee should constitute of 10 panchas of
yes,
whom
yes,
that is one.
yes,
Next, the district shall not, number 2 is,
yes,
the district shall nominate 2 panchas from the residents of Devarguda after consulting.
yes, yes. That is category 1.
that
That is
is two.
category 1. That is category 1. Yes.
Of whom the so and so.
Mamledar is ex officio member. Out of 10 panchas, local Mamledar is the one pancha, ex officio. So remaining 9 to be, my lord, appointment of remaining 9 panchas shall be made.
No. you-
Only
appointed these-
submission, my lord. This committee is already constituted 6 months back. So maybe I will secure records on that, this aspect.
No, it is simple instruction. Now
Please.
you have appointed so and so under category 2, saying that he has endowed either he should endow in terms of cash or property
Please.
to the temple. Whether he has done it or not is a simple issue.
please.
It should have been before you. If not, they are not entitled.
Please, we'll examine that, my lord.
We'll have this matter on Wednesday. And
Meanwhile, madam, only submission is that, madam. In the matter 230, that is the question is whether the scheme,
not
no,
taking that matter of 230 today.
no, on that the same day maybe it may be taken. In the event, my lord, if this honorable court holds that, my lord, this is an endowment temple, the scheme framed under the old act will lapse. Automatically, the district and session judge will lose the jurisdiction, my lord, and these matters will not survive for consideration. That is my most possible submission. So therefore, my request is that, my lord, see that only 5 minutes I will convince this honorable court, my lord. There is no operation of stay for the act, my lord. The act is in operation. Now the district.
Elaborately we'll hear it
Please.
on one day. Today, this 2:30, like Thursday.
Please. No,
because I have
on
to
the
go
same day it may be taken along with this matter.
Wednesday we'll have at 2:30.
Along with this matter.
No notification, Lord, the district judge has no authority to, Lord, constitute.
Yes, so then this also will have it on 2:30.
It may be connected with that matter, my lord. This matter also may be connected with that.
Along with that 2:30 matters on Wednesday at 2:30.
Please.
Yes.
Number 43.
43, my lord, is appellant.
Hmm.
Its appeal, my lord, along with suit, my lord, application for injunction was filed. Plaintiff's appeal, along with the suit, application was filed for temporary injunction. That application is rejected by the trial court. Lord, I have placed the material before the court that it was a granted land in favor of father of.
Please come to the order. Let's see why it is
Please, please.
rejected.
Page number 15, reasoning part, your lord.
Yes.
These points are interconnected to each other, hence I would like to discuss these points together at one stage to avoid repetition of facts. Plaintiff have filed this suit against the defendants for relief of declaration and also consequential relief of permanent injunction, and also maintained the application 39(1) and 2 for seeking interim order of TI against the defendants, restraining them from interfering, trespassing over the suit schedule mentioned property. Further submits that the suit schedule property originally government Anadena land, and the said land was granted in favor of his brother and father of the plaintiff number 1. After demise of father of plaintiff number 1, mutation was effected in favor of plaintiff number 1 on inheritance. The defendants are not in the absolute owners of the suit schedule property, and they are illegally trying to grab the suit property by causing obstruction to the peaceful possession and enjoyment of the plaintiffs. To establish this case, plaintiffs, they have produced the documents RTC 23, 24 and 1 genealogical tree, death certificate of grandfather of plaintiff number 1, and also furnished copies of orders of learned assistant commissioner, deputy commissioner, and xerox copy of Sagwadi chit, which are clearly shows that the death certificate shows that one Ninganagowda Basappa was the died on 13/9/2022, but his father's name has not been mentioned in the said document. On perusal of genealogical tree, it shows that Ninganagowda Basappa and Basavegowda are the one and the same. But there is no document to show that Ninganagowda Basappa, Basavegowda are one and the same, and also furnish the Xerox copy of certificate regarding issuance of Sagwadi chit. It reveals that name of Basavegowda 2 times rewritten the name of the Basavegowda. Hence, prima facie, it is not a believed document. But on the other side, defendants have filed application under RTI before Tahsildar, but he has issued an endorsement stating that Xerox copy of Sagwadi chit produced by Plaintiff is not available in the office of Tahsildar, Kudligi. Hence, it is very much doubtful to say that how the Plaintiff has obtained the said Xerox copy of Sagwadi chit is not explained in the proper manner. The RTC extract is of the year 23-24, stands in the name of Plaintiff as per.
I've seen.
Please. Lord, already the issue is considered by Assistant Commissioner and Deputy Commissioner. They have passed the order. Based on their orders, name of the Plaintiff is entered. And on the other hand, one more request more in the very same paragraph. What they refer to is they are claiming survey number 253/P measuring 4 acres. Our suit property is 3 acres.
No, his name is right from 90s till 2023, his name is there.
No, my name, their property.
Name is there, that's what is recorded by the
The
court.
main confusion is they are claiming property 253/P measuring 4 acres.
Perusal of the revenue documents, more particularly RTC extracts and Sagwali chit filed by the defendant since 1969.
His Sagwadi chit is set aside by the Assistant Commissioner, went up to this court in writ petition, it is confirmed. On the ground that Tahsildar has no right to grant the land. It is to be by the committee. So to place the application before committee, that is confirmed up to this court in the writ petition. So they have no right, and they are claiming 253/P measuring 4 acres.
Where are those orders in the writ petition?
Please.
Where are those orders in the writ petition?
No, this is appeal, my lord. I have not placed it.
Please
The-
place
the-
before
Yes,
the
yes,
court.
I will place all those documents.
This is matter on Thursday. Yes,
Seal number 44, Harishas Maigur.
notice. Yes, 46.
Seal number 45.
My lord, 45, I am for the appellant. This is an ECA matter. ECA matter. Our whole amount is deposited. They are withdrawing that.
Claimant, my lords. Claimant, my lords. In the ECA matter, my lords, it is not a substantial question of law, my lords. Since they have questioned the employer-employee relationship. On this basis, my lords.
Other aspect, jurisdiction, everything have challenged.
List on Tuesday.
Tuesday.
Yes.
7.
My lord, they are withdrawing the amount, my lord. At least they must be prohibited to withdraw the amount. That's the only request for me. I already deposited entire amount. They
I'll
filed
hear
application.
Whether you have made out a substantial ground, a question of law to admit this appeal. That I will
But
decide on Tuesday.
at least till that date, they should not withdraw the amount. I say.
This is a matter on Tuesday till such time, the respondent shall not withdraw the amount. Tuesday, we'll hear the matter, yes.
46, NP Vivek Mehta. B group.
Petitioners or plaintiffs. Suit is for permanent injunction. I moved an application for the order 39-192. Both the courts have.
1 minute, I've heard. It's only for disposal, this matter is coming up. Yes. Where is that?
Only thing is, my lord,
Report.
trial court and the first appellate court dismissed it on the only ground that whether it is granted as an individual for the benefit of the family.
This is which year?
2021.
2000?
Suit of year 2021.
Please come.
My lord, one thing, both the courts said that whether it is granted to a individually or family, land grant rules has defined that family, my lord, they will not come under those family. It is family means wife and his sons. I had produced the grant certificate. Prima facie case, it has established that the grant is made to me.
Suit of 2020 till now you have no injunction. What is the purpose of deciding the injunction petition at this stage? That's why I have asked for the report. We'll ask the court to dispose of the main suit itself within a time-bound manner. The present petition is filed, questioning an order passed in so and so. Both the courts have concurrently held that the petition is not entitled to injunction. Land counsel for the petitioner has argued the matter. Both the counsels have argued the matter on merits. A suit of 2021 till 2026, there is no injunction and the matter is pending. At this stage, this court is not inclined to go into that aspect. And in the facts and circumstances, this court deems it appropriate to direct the trial court to dispose of the main suit itself as expeditiously as possible. Accordingly, this court is passing the following order. The writ petition is, this court is not interfering with the orders passed by the appellate court as well as the trial court as well as the appellate court. Appellate court can only on the aspect that the suit is of the year 21 until 2026. He has no injunction in his favor. That's why the court is not expressing anything on the merits of the matter. Number two, the petitioner, the court shall dispose of this matter as expeditiously as possible.
Please. Great.
Yes.
Your Ladyship, for the petitioner in 47, Your Ladyship, this is a 2022 matter. 47.1 is a fresh matter recently filed. Two factions of a cooperative society having a dispute amongst each other as to which is the more legitimate faction. I want to come on record and say one thing, Your Ladyship. I have filed a challenge basis the fact that the Registrar of Cooperative Society has accepted my rival faction's document without conducting a mandatory inquiry which is stipulated under the Act. They have sought cancellation of the acceptance of my returns by the very same.
Let's see on Tuesday. This Tuesday. 48.
48. See number 48. B. Sharana Basa.
Kindly pass over, my lords.
No pass out today. This is matter on Friday. Is 49.
Lords, not on Friday. Next week, Tuesday, my lords.
Yes, next week Tuesday.
And interim order may kindly extend till then. Please.
See number 49.
I said next week Friday, not this Friday.
Next Friday, please, please, please.
Yes. 49.
This matter pertains to parole, my lords. 47 next week.
Huh?
47, my lord.
Huh.
Next week, my lord.
What I said next week only. Yes, 49.
49.
It's case of parole, my lords.
Case of parole, lords.
In 49, take for in 49, 108062. The present writ petition is filed, seeking the following prayer. It is a grievance of the petitioner that the petitioner is a wife of convict who is lodged in Central Prison, Dharwad, as convicted convict prisoner and is undergoing the sentence of life imprisonment for offences punishable under section 302, 143, 147, 148, 341 of IPC in SC number 05 of 2016. And the criminal appeal filed by them was dismissed by confirming the orders passed by the trial court. Against that, he preferred a SLP and the same is pending consideration. It is a case that he has already undergone 3 years, 1 month, 12 days imprisonment as on 2010-2025. The wife of the convict is suffering from cervical spondylitis. So what he has to do? In a 302 appeals, cervical spondylitis, on these grounds will parole be granted?
As per the scheme is provided by the government of Karnataka itself is the available.
Cervical spondylitis also.
Only intention of the lordship, only intention of the granted parole to mingle with the society as well as the family lordship. After the only release after the completed of the conviction period also is not possible to adjust the society. For that sake,
Generally, in all these
in same case of in
all these offences, generally where there is medical emergency, where there is family emergency, those are all the things that would be considered. So in the what I can understand from this framework of whatever you are mentioning, so every life convict means every after every what is it in a year 90 days, again after 6 months, again for another 90 days, he can be on parole.
No, what happens in this, in such a situation, Lordship, even though parole is granted, Lordship, it not reduce the sentence, Lordship. Only postpone, that is the only, Lordship. Only for, that is only, that, this, for this,
That she's
as per
suffering
Supreme
with
Court order itself, only the rules is framed, Lordship.
He made a representation to respondent number 2 for grant of general parole. Then he has called for a report from respondent number 3. And respondent number 3 submitted a report on 24/4/2025, wherein requested not to grant parole to convict on the basis of the report submitted by respondent number 3. And respondent number 2 has not passed any order in the earlier order, all that entire thing, extract that. When the petitioner, when a representation is made seeking parole, the respondents are supposed to consider the same as per Rule 191 of the Karnataka prison rules. And the respondents cannot, the respondents, just like that, by calling for a report, they cannot keep quiet. In view of the inaction on the part of the respondents, every day in and out, there are several matters, several cases are coming before the court seeking parole. Under Rule 191 of the prison rules, when the respondents are bound to pass an order, why they are not passing the order is not known to this court. Hence, the writ petition is disposed of, directing the respondent number.
Concerned respondent has not, Director General has not made as a party.
No, Lordship. The 3, Lordship.
3 will not
No,
grant you.
3 is only.
He will forward it to the Inspector General of
Reports,
prisons.
he has only sent a report.
Huh?
As per rules, you have to transfer to the.
Looking at the rules only.
Please, Lordship.
The ultimately you have to ask the person. Now, Superintendent of prisons, you will make a representation. He will call for a report. Both this, he will send it to the Inspector General, isn't it? That's what 191 says.
Please, Lordship.
The Inspector of Prisons shall consider the case of the petitioner in accordance with the law. The Principal Secretary Home shall give general instructions to all the authorities concerned how an application for parole has to be considered by fixing a timeline. And in this manner, what the respondents are supposed to do, they cannot, and with unnecessary litigation by the because of the inaction on the part of the respondents, the writ petitions are filed before the court. Same, the copy of this order to be communicated. Next matter,
it is rejected, Lordship, by the respondent to 3 itself, only rejected.
how can he reject it?
It has to place before the DIG.
No, in this matter, in the next matter, the facts and all I'll dictate later. It's already 142. Yes, 50.
Still number 50. You sum up.
Disposed of. Next matter also. Is 50?
I'm for petitioner, my lord. The petitioner is the defendant in the OS suit 140 of 2003, which is pending on.
Urgency?
My lord?
Any urgency?
My lord, the trial has already been commenced and they have filed the IA for amendment.
Tuesday. Yes, 51.
Number 51, A.B. Patil. SS Mittal Court.
Considering the affidavit, undertaking affidavit filed by the petitioner may be disposed of, Your Lordship.
What is
The sale proclamation is stayed by this court to condition.
What is have you seen the undertaking of?
Yeah, I've seen that they have undertook to pay 10 lakhs within March 31st and the remaining by May. We are okay. We have no objection.
Disposed of in the light of so and so. I'll dictation and later. Yes. Disposed of in the light of the undertaking dated so and so.
Please.
Yes.
Both matters, Your Lordship.
Both the matters.
Both
Yes.
Yes.
Is 52?
Still number 52.
I appear for petitioner. Elections are over. The returning officer.
Where is the returning officer?
The society is appearing.
52. G.V. Bharmgowda. Vijay Kumar. And
5, Lordship.
13-2 is not complied, Lordship. 13-2.
Compared with 13-2.
Please, Lordship. No notice was issued, Lordship.
Same order.
Same order. Earlier, lordships have disposed.
When counsel appearing for the returning officer submits that there is non-compliance of 13-2.
And returning officer also. I am for the society, Lordship.
A society submits that there is no complaints of 13-2.
Please, Lordship.
And now Your votes have to be counted.
Yes.
And what is that order?
The votes have to be counted and sections.
Where is that order?
Yes,
Take that. Similar order.
please. Last page.
Yes, next.
Election results have to be declared.
Yes,
Public.
53.
Great flush.
53, further hearing matter.
Yes.
53.
I don't think it's possible today. We'll have it on Tuesday 2:30.
Please. Yes.
Matters 2:30 at Tuesday, on
Good.
Tuesday. Yes.
Interim order may kindly. be.
Matters interim order is there, wherever adjourned matters. Interim order is there, extend. Yes, next. 56. Oh, this is not batch. 54.
It is infructuous only, my lord. It is to be disposed of.
All matter.
Infructuous only. It is infructuous only. It is to be disposed of, your
It
lordship.
becomes
because-
infructuous milords on 6/3. What happens is milords, challenging the milords order milords in FDP number 11/2021. The petitioner herein milords had preferred milords RA. Milords, what happens is milords, as per annexure E milords, a detailed order comes to be milords passed milords, they staying milords the proceedings milords.
Still, it has become infectious or not?
Milords, it would become infructuous milords on 6th milords for the reason that it is posted on 6th for pronouncement of judgment. Till 6th milords, let them not take any.
My lord, there is no any interim order, even in this
My lord, this
honorable court as
honorable
well
court-
as in
We
that
will
court.
not grant any interim order.
Well,
no.
interim order,
There is no interim
it is
order.
already granted
Posted for judgment
on 6/3.
is coming up on 60. Hence, nothing survives for consideration
Well,
in this
till-
petition.
No,
Accordingly
there was-
dismissed.
There was already interim order granted by this honorable court, milords.
Not granted.
It is vacated.
Milords, the court has directed, let them not take notes because they have filed execution parallelly.
It is not a stay. Why will we say that?
Well, milords, what has happened, milords, this honorable court clarified that let the court pronounce the judgment and let them not take possession till then,
Where
till
did
6/3.
Where did the court say? Show it.
15/10/2025. It was modified, milords, on
Please tell the date.
1810. 1510 it is also. 15. 15/10/2025, your lordship.
31. 15/10 milords, a detailed order came to be passed directing the court below to pronounce the judgment.
Where is the order of your stay in your favor?
Milords, that is granted milords by this honorable court milords on, milords, a detailed order milords on 11/8. 11/8. On 6th milords, it can be posted also. Otherwise, not still 6th milords, let them not precipitate.
Says, order dated so and so is
State.
stayed in the next state of care.
How?
Next state one.
Permitted them to go ahead with the. Anyhow, what is it you are going to lose? It is only.
Because of the pendency of this petition, your lordship, the
No,
lower appellate
I-
court is not passing the judgment.
Disposite of saying that till the judgment is pronounced, don't do it and
As-
don't do
sir,
anything.
It is not- The judgment is not pronouncing, even though it was posted earlier also
No.
for the judgment because of the pendency.
If you invite an order on merits, I have to hear it on merits. You can't ask for both.
No, my
Now
lord.
I'll say the writ petition has, no, they have questioned and the matter is posted for a judgment.
Judgment, it is
Since the
posted.
judgment is pronounced, no coercive steps should be
Please, ask-
taken and accordingly disposed of.
Please.
If that is a order acceptable to you.
We are not taking any course.
Petition is filed seeking the following prayer. Initially, the stay of all further proceedings is granted. Thereafter, the court has permitted the court as far as going ahead with to take up the matter. And now it is submitted that the matter is heard. It's coming up on 6/3/2025, 6 for pronouncement of judgment. Now, hence, the writ petition is at this juncture, no inquiry is required on the application. Accordingly, the writ petition is disposed of, and till the judgment is pronounced on 6/3/2024, respondent shall not take any,
In RA number 5069/2020.
not take any coercive steps.
Please.
Next.
Please.
Bill number 55.
Let it be till pronouncement of judgment, not see if on 6/3 the judgment is not pronounced.
Till the pronouncement of judgment. Yes, 55.
Till, please.
55.
Yes, 55 also. This 55 on Thursday, 56, 57, 56 on Thursday. And these two matters, if a stay is there, extend, then 57, 58, all these final hearing matters.
My lord,
give
one
some-
submission, my lord. 58, my lord. Lords, this is the amputation case. Last date of hearing, lords, he was also present. Some urgency, my lord.
What do you expect me to do? I'm not sitting in the afternoon.
Tomorrow, my lords, at least.
Tomorrow also I'm not sitting. This is matter on Wednesday. What are the passos? Yes.
So 57.
11,
Yes, 11.
passport matter 11. Chuvashiru, 11.
Lord, Wednesday, 2:30, my lord. At MFA, 2:30, my lords, Wednesday.
Yes.
Please, my lords, much obliged.
Please, pastor matter, my lord, that KSBC place of voting.
I'll pass on the orders, my lord, of the honorable.
I've seen, my lord, high powered committees are constituted. The only grievance in this case is after the completion of KSBC election.
The whole elections.
Yes.
Please, my lord.
Constitutional High Court Committee is not.
No,
the
I'm
High
not
Court.
disputing.
And moreover, what
Not
happens
disputing
is-
that aspect, my lord. Only, my lord, the purpose for seeking change of place of voting was that, my lord, pursuant to this election, my lord, the local bar association election will be held. If, my lord, she is,
Time to examine it.
yes, ma'am. Tuesday it may be taken.
One submission. One submission.
What about your case undertaking?
Please.
No, your, is it acceptable?
Please, my lords, I'm ready to deposit the.
Counsel for the petitioner submits that the court has directed the petitioner to deposit 1 crore and odd without there being any material. It is submitted that what the petitioner, what the plaintiffs are seeking is only 2/9 share.
Please.
And even assuming that they are entitled for anything, the court ought not to have directed the petitioner to deposit entire 1 crore, 1 crore and odd.
Please.
Considering all this, they shall be stay of all further proceedings pursuant to the order dated so and so, on the condition that the petition shall deposit 20 lakhs within a period of 4 weeks.
Please.
4 weeks from today. The petition shall take out hand summons on the counsels appearing for the respondent before the trial court and shall file a memo to that effect.
One more submission, my lord. Your lordship may direct me to deposit the amount before the interest-bearing nationalized bank account, my lord.
The shall be deposited before the court and the same shall be it shall be placed in a deposit in a nationalized bank.
And withdrawal may be deferred until the disposal of the suit, my lords. Withdrawal of the amount may be.
No, why will the court permit withdrawal?
No, no.
It is only securing it.
No,
Why
Lord.
will it give to the plaintiff?
In
That's
the
not
event
the
if-
part of the order.
No, my lord. In the event if they file an application for withdrawal.
Not permit. Court never said. Court has not even decided that they are entitled. That's what the court said.
Please.
It will not do it.
Lord.
Let's not pass further orders. Yes.
I'm seeking dispensation of notice to respond number 3 to 9, my lord.
3 to 9 memo is taken on record and the notice to so and so is dispensed with. Yes, any other passo?
My lord, serial number 16, your lordship has directed government to secure the instruction whether entire amount has been made or not. But it is the respond number 1 who, private bank who has to answer this, my lord, not ARCS.
Then what to do?
I'll take hand summons, my lord.
Hand summons to which respondent?
Respond number 1.
Respondent number?
1.
My lords, earlier order may go. It was directed me to take my lord's instructions with respect of deposit of the amount, my lords.
Earlier an order was passed asking AGA to get instructions. Now there shall be a, the hand summons to so and so because we will see once you serve the hand summons.
Returnable date. Returnable date. Okay. Returnable, please.
When do you want?
Next week, any date, your lordship. Please.
Friday.
My lord, may I request hand delivery of the order?
Hand delivery of the order.
Sir, 58.